Which matter?
It is not listed. I would like to be listed. Next week, Friday.
For admission order?
For admission, madam. This is a suspension case.
Admission, Friday.
Friday or Thursday, madam. Next week.
All right, Thursday.
Of license.
23rd.
May I please? Item number 15, 16, and 17.
Item number?
15, 16, and 17. When the in this case, DPC has filed affidavit in opposition in connection with double petition of pipeline type column. But I did not receive the copy. So may be allowed.
Where is BTC? Yes, you filed it.
Yes.
You know, serve copies.
Lordship, 15-6 file, but yes,
15, 16, 17, request made by the council for the petitioner, matter still referred to be listed after 3 weeks, as it is submitted that the affidavit has been filed by the PTC authorities. They would like to file a rejoinder. Please take order.
I'm for the respondent in this case.
Mr. I. Soikia appears for the respondent. You are for the petitioner in second matter.
In two matters, I am for the petitioner. In one matter, I am for the respondent.
Yes.
Question fix a date. I have some urgency. In fact, item number 15 has become infructuous.
List on 12th. Item? 15 is mentioning in 15.
It has become infructuous in fact, because he has challenged my appointment as in-charge principal. Both of us has been transferred from the school mind.
Oh, 13th of August.
Okay. Very pleasure. I get pray on behalf of Mr. J. Abidin, madam. Item 12, madam, will be adjourned today. He informed me over telephone, madam. Medical.
Item 12 on the request made on behalf of Mr. J. Abidin stands deferred to be listed after 2 weeks.
And may I please, item number 13.
Yes.
An additional affidavit has been filed on 15/7. Lordship, the same may be called on record.
Additional affidavit filed
By the respondent.
by the
Respondent number 2.
item 13.
But the same may be
Additional affidavit for filed by the respondent when?
on 15th, yes, sir.
On 15th.
Lordship.
Then why today? Then let it go to some other date.
Lordship, advocate has come from Delhi.
Advocate may have come from anywhere. What has that got to do? You filed it yesterday.
We filed it before it.
All right, 13. Get the affidavit.
Lordship. Much obliged.
Right, please. Lordship, I beg to mention for listing of content term of order. May I pray on next 24th, 2024.
Did you take any date before or after?
I am praying 24.
28th.
I am paying for listing of a fresh contempt case. My lords have given an interim order to not transfer the petition. Despite that, they have passed a transfer order and the writ petition is listed tomorrow, my lord. I am praying that the contempt may also be listed.
All right. Is it filed?
Filed.
Obliged.
Lordship, I beg to mention item number 31, Lordship. The concern of the other side, Lordship. This matter will be come after weeks, Lordship.
31 on the request made on behalf of the respondents. Matter stands referred to be listed after. Who's for the petition?
One date may be fixed.
Why date? Is it listed today? Why date is necessary? It should come in the part 2 hearing list. Matter for hearing. Let it be in part 2 hearing list in the month of August. Apply. Orders.
Yes. I needed lordship next week.
27 July.
August.
Please, Lordship. Lordship, I beg to mention for listing of arbitration, tribunal fight, arbitration.
When did you file it?
26. Lordship, we have issued notice in the month of May.
All right, 27, 2020. 20.
And the last one.
Last order.
Instruction,
Instruction, yes. What instructions have come?
No, we have not received any instruction, madam.
Huh?
We have not received any instruction, madam.
The matter was listed because council submitted incomplete instructions.
Yes, ma'am, I have not received any instruction.
Okay, basically, we have filed this case to dispose of the matter in terms of the division bench orders.
That is the instruction, whether it can be disposed of. That's the only thing you need to tell us. You don't have a copy.
I have, madam, this one is mine, ma'am.
You go through it, we'll call up after a while.
Yes.
Or in the second half. Second half.
At 2
At 2
at 2
PM.
1.
Yes. Both the matters.
Yes, both the matter.
Both the matters.
Yes.
At 2
Because
PM.
there is a notification of 2025 by which some additional documents are also we are required to also submit. So accordingly, let's see, the direction is given to submit the document and then dispose of.
You examine it
That's
whether it
it.
can be closed in
Yes,
terms of the division bench order.
Yes, madam.
Yes. Huh? Mr. Katodia?
Yes, madam.
Yes, what?
This is the division bench direction.
That we have seen it.
Yes,
We
madam.
want you to tell us whether it can be
Yes, yes.
disposed of in the
That can
same
be
terms.
it can be disposed of.
Right, council to the purpose. Yes. The development by petitioners. Were submitted their application in response to the advertisement dated 26/12/20, filling up of 3,800 assistant teacher in lower primary and 1,750 vacancies of assistant teacher in upper primary. Stop petitioners applied accordingly as per their eligibility. Thereafter, by notice dated 1/24, issued by the respondents, the petitioners who had completed 18 months E full stop EL full stop ED, within bracket ODL, sorry, bracket close ODL from NIOS were disqualified. So, subsequently, an issue which traveled to the Supreme Court, the apex court, by an order dated 10/12/24, upheld the validity of the 18-month DLED diploma for in-service teachers who were on employment as on 10/08/2017. You are also in-service teachers.
Yes. Prior to 10
The petitioners are also in-service teachers, and therefore they claim the benefit of the judgment of the apex court rendered in 2020. So, one of the petitioners that the respondent authorities, instead of compliance of the directions of the apex court and giving the due benefit to the petitioners by considering their cases by considering their eligibility for appointment posts which are advertised, the express conditions like admission slips, UDISE codes, minutes of the school committee, school management committees, authenticated attendance registers, salary slips, and other institutional records which are not available with the writ petitioners, and they contend that it is impossible to punish them. So, similar writ petition which came to be disposed of by a coordinate bench, in an appeal, preferred intercourt appeal, preferred writ appeal number 345 of 2025, a division bench of this court disposed of said appeal by order dated 24/03/26. Whereby it was held that the appellants therein, the cases of the appellants shall be verified by the state on the basis of the documents furnished by them, and if some of the documents demanded by way of notification 17/6/25 are not furnished, the same shall be verified by the state from their own records and databases. And in the event of the rejection of the applications of the appellants therein, each of the appellants shall be communicated the reasons for such rejection. So, there are the learned counsel for the petitioners submit that the petitioners are similarly situated, and the order of the judgment and order of the division bench in writ appeal number so and so squarely covers the case. Therefore, similar orders have been sought for in the present writ petition. There are on 26/6/26 and 14/7/26, the State Council was permitted time to obtain instructions in the matter. Today, when the matter is called up, the Council for the respondent submits that the petition, the writ appeal number 345 of 2025, wherein the order dated 24/3/2026 was rendered. Can be the basis of disposal of the representative petition. Stop. It is submitted that it is submitted at the bar that the present writ petition can also be disposed of in terms of the said order. But accordingly, since the counsel for the parties are at ideal that the issues raised in the present writ petition is then covered by the order dated so and so. This court proposes to dispose of the present writ petitions in terms of the same similar direction which are issued in writ appeal number so and so by the order dated so and so. The relevant paragraphs of the judgment of the order of the writ appeal expected below. Accordingly, the writ appeal stands disposed of, directing the respondent authorities to process the applications submitted by the writ petitioners and examine the documents submitted by the writ petitioners along with their applications. And if any further documents as sought for by the respondents from the writ petitioners are not available or are unable to be furnished by the writ petitioners, then recourse shall be taken to the database or the records of the state, verify verify those documents as the same are already available in the custody of the state. So, upon due verification, if the petitioners are found to be eligible, consequential orders shall be passed. In the event their cases are rejected, then each of the petitioner shall be communicated the reasons for their rejections. In terms of the above, the petition stands disposed of at the stage of the motion without issuing notice. Disposed, Mr. Bora appears for. Mr. Bora, Mr. N.S. RB Boro.
1 and 2, man.
RB Bora appears for 5, and Mr. Alan for respondent 4. Mr. A. Sharma for petitioner in WPC.
3521.
3521, and Mr. Sarkar for 3514.
351.
Disposed.
8 accounts.
8 acres.
So the verification be done in a time frame. That is reflecting the
What is the
3-month time.
verification?
3-month time was given.
Verification shall be done within a period of 3 months from the date of receipt of a certified copy of this order.
Obliged.
Kindly pay the last order, 8626, and then Mr. Bora was sought some time. 8626 order. That's when a 23. Seeking benefits. The whole pension scheme. Order is 8626 medicine.
The finance department for consideration, my lord. We have not received the consideration from the finance department. Before the finance department for consideration, my lord.
Where is the finance council?
Finance is
Any finance council here?
not a party in the contempt.
All right, let us call him. Let it be for the time being.
My lord.
You are for the finance? Yes. By which, where is the proposal by which you have sent it?
My lord, this was sent on, my lord. 5/2/2026.
Do you have the copy of the proposal?
My lord, proposal is not there, only communication sent us by the secretary, that is
You
there.
serve them a copy.
My lord. That's-
You find out what is the status of the proposal sent from the education department pending at the finance department and apprise the court. After 1 week, 27th. Release this matter on 27th. MS N. Hazarika, appearing on behalf of the finance department, is requested by the court to apprise the court regarding the status of the proposal stated to have been sent by the elementary
My lord.
education department by the communication dated
5/2/2026.
5/2/2026, and which is stated to be pending before the finance department. The counsel for the petitioner will furnish a copy of the contempt petition, and the counsel for the education department will furnish a copy of the communication where the proposal, where there is a reference of the proposal being sent to the finance department.
Obliged.
Non-compliant order dated 28/10/2005. Is the petitioner not to pay the salary?
Credit card not received.
My lord, kindly see my lord, order dated 3/6/2026, my lord. As per my
You
information.
have to take fresh steps.
Yes, already taken.
When?
My lord.
There is no endorsement here.
My lord, this step is taken, my lord, 18/6/2026.
18/6.
Yes, my lord.
No endorsement.
Earlier, my lord, the order it is reflected that the I think delivered to the petitioner.
By earlier order dated 17/6/26, the petitioner was permitted to take fresh steps for serving a notice on the sole respondent within the stop submitted by the counsel to the petitioner. That fresh steps was taken on 18/6/2026. Stop office to verify and make necessary endorsements and also indicate on the status of the service of notice on respondent. Release this matter again after 2 weeks. 31st July.
Intentionally avoiding smart information, my lord.
Let us see. You
Yes,
want to take Dusty?
Dusty did not agree to leave my lord. Some, my lord, please be with my client, my lord.
All right, can you wait for 2 weeks?
Yes, ma'am.
This one I have filed an IN. Amendment,
IA or
amendment.
Huh?
Amendment.
amendment? Any objections to the amendment? Huh? You want to file an objection? Objection for amendment? Heard counsel for parties issue notice returnable 4 weeks. MS.
NM Sharma.
Huh?
NM Sharma.
NM Sharma appears for
Respondent number 6, Lordship, secondary education.
respondent number 6. MSP Chakraborty appears for
3.
respondent number 3 only.
Only 3.
Mr. D. Upamanyu for 4, 7 and 8.
4, 5.
4, 5, 7 and 8. Who's for 1 and 2 state? 5, Mr. B. Chaudhary. You are for 4? 4, 7 and 8. Who's for state? State council? You are there? Mr. Bora appears for respondent 1. Let the respondent file their objections, if any, to the IA filed by the petition.
This is an IE for recruitment of new incumbents as respondent number 4 and 5.
4 and 5. Who is 4 and 5?
4 and 5, my lord, the new, my lord, district elementary education officer and deputy commissioner. Earlier, Apurva Thakuria and Kirti Jalli were there, my lord. They are no longer there.
So you want to include who?
Tapon Kolita as district elementary education officer and PK Mishra as deputy commissioner. At page 21.
21. IA.
IA.
There is no 21 in the IA.
6 months.
Any objections?
No, I'm appealing for respondent number 1, madam.
Heard counsel for parties. Contempt petition on his file. Disobedience of the judgment and order of the order dated. So passing the submitted that the respondents 2 and 3 have in the meantime independency of the contempt petition delivered their office and new incumbents have been appointed. Accordingly, an application is filed seeking increment of the present incumbent in the office of Deputy District Elementary Education Officer Kamrup Amingao and the Deputy Commissioner / District Commissioner Kamrup Amingao. Chairman District Level Committee Amingao. So counsel appearing for respondent number 1 does not object to the prayer made. Considering the submissions made, the government PIA, this court is of the belief that every state, the right can be allowed without issuing notice and calling for objection as respondent. File their objections or affidavits in the writ petition, in the content petition. Accordingly, I stand allowed Sri Papan Kolita and Sri D.K. Misra are arrayed as district elementary education officer, are arrayed as Papan Kolita district elementary education officer, Kamrup, Amingao, and D.K. Misra, deputy commissioner, Kamrup, Amingao, are arrayed as party respondents number 4 and 5. Contempt case number so and so. I accordingly stands allowed disposed of. The applicant will file amended post title before the registry within 1 to 2. In the contempt case, you write in view of the order passed today, I number so and so, has been arrayed as party respondents. Petitioner will file amended post title within a period of 1 week from.
I may be allowed to take steps, madam, on.
No, first you file it, then it will come, then we'll issue notes.
Authorized. Here in this matter, Lordship, we have received certain instructions from the principal of the various colleges wherein the petitioners are working, Lordship, but the instructions are not appropriate, Lordship. So we need to further time, Lordship.
Yes.
Lordship, as per order dated 11/5/2026, instruction was sought for from UGC.
But they are not made a party here in this.
This contention was raised earlier, but still, as per order,
You are calling for, you are seeking instructions on whom they are. You are representing which respondent?
1 and 2, Lordship, the higher education department.
1 and. Then
can you produce the order dated 11/5/2026?
what is your grievance here?
Lordship, as on date, we are working as tutors, and our service is now provincialized. And
What
these
instructions are sought for from UGC?
whether our PhD degrees are genuine or not. And as per they claim that our PhD.
Let that instruction be first placed by the higher education. Have they questioned your degrees?
Yes.
Lordship,
The
yes, they
thing is that UGC is a necessary party in this writ petition. They have not made them a party.
No, where is that objection by the respondents that your degrees are not genuine or acceptable?
Lordship, whenever we file our representation for our representations are yet
Where is the objection of the state? By which document?
currently peruse annexure 6,
Page number
page number 43, Lordship.
33,
43.
43. Yes.
They are as on date they're working as tutor.
We are asking you a question that their qualifications are not as per UGC is an objection raised by the state. Where is that objection?
Take instruction for it.
Counsel for the petitioner seeks time to complete instructions least after 4 weeks. Mr. D. Upamanu appears for the respondent.
If in this matter, Lordship, instructions are yet to be received, Lordship. I am praying for Lordship 2 weeks further time, Lordship. Both the matters.
There is some interim order.
Yes, Mr. 15/9/2025.
We'll give you 6 weeks. He's got an interim order. Why should we be concerned? Take 8 weeks. No,
Lordship, 2 weeks is
2 weeks, sure. Why are you taking in installments? Take it now. You're giving it in a wholesale, 6 months, 8 months, whatever time you require. Third counsel for the parties, the standing counsel, higher education,
Yes.
prays for further time, releases prayer for further time. Next time. Mr. B.K. Das counsel. For immediacy. But you are a pro forma respondent. Yes. No claim. Accordingly, the matter stands deferred to be listed after 4 weeks. Interim order, if any, passed earlier, will continue. Until further on.
Now, item number 8 is the same.
Similar.
Same order, yes,
Same
similar matter, same order.
Deeply. Others.
Lordship, can you peruse the last order? Last, no,
Terms of,
Huh?
terms of order dated 20th March 26, my lord. 20th March 26.
20 March 26.
26 instructions,
20 March.
March
28,
20,
20.
20,
There is no 20 March.
20th March.
28 March. Passed by code number
Item, item number 10.
Item 10.
10. To listen.
Yes.
Two of the above. First.
In view of the above, Mr. R. Burwan, Standing Counsel, Secondary Education Department, to obtain instruction as to whether the post in which the petitioner were appointed are sanctioned post.
What is your
irrespective of-
grievance?
Terms of this order, my lord.
To me,
So Lordship will kindly come to pay 10-6, my lord.
8?
10-6, my lord. Order dated 10-6.
10-6.
10-6.
All right.
Terms of this order only, my lord, instruction as regards 3 petitioners, my lord.
Who's to obtain the instructions? Standing counsel, secondary education.
Secondary education.
Class President Q. Sharma was it?
So now the instruction is to be obtained whether
Obtained whether the others candidates which are
What is your grievance?
in this case, my lord, this honorable court passed an order to regularize the services of the petitioner who are working as a contractual basis for the time being 3 months, 4 months like that, and until later on until further order. Then I approached this honorable court. This honorable court passed an order to regularize the services of the petitioners as per Uma Devi. Then they have filed review petition. In review petition, page 85 to 99, madam, it is stated that they will appear the petitioners this page 105, para 18. 105, Lordship, can you peruse? Para 18. In the circumstances, we require the individual writ petitioners to make an application before the Secretary to the Government of Assam in the Secondary Education Department, stating in detail the dates of appointment, the name of the institution where they were appointed, the procedure adopted for such appointment, the process of which the appointment were made, as well as the post creation number, if available. Upon the individual application being submitted, the Secretary to the Government of Assam in the Secondary Education Department shall call for the individual records from the respective schools where the writ petitioners were appointed. From the records, the Secretary shall verify as to what was the number of the sanctioned post in respect of the post where the individual petitioners were appointed, and also to find out the as to whether the whether on the day when the appointments were made, any of the sanctioned posts, if available, were vacant. If the answer is in affirmative, it has to be understood that irrespective of the manner of appointment of the writ petitioners, they were appointed against sanctioned vacant posts. If the conclusion arrived at would be contrary to the no sanctioned vacant posts were available on the day of the appointment were made, the conclusion may be arrived to the petitioner concerned were appointed against the any sanctioned vacant post. If the conclusion of the arrived at is that the person concerned were appointed against this sanctioned vacant post. The provision of the two judgments dated 38/9/2015 and 22/2017 requiring their regulation as to on-time measure would be applicable and also be complied with. In respect of those writ petitioners, where the conclusion arrived is that they were not appointed against the sanctioned vacant post, it would be for the authorities in the secondary education department to take any appropriate decision against them as may be available under the law. The review petition are partly allowed only to extent indicated above and the conclusion that there was no dispute that the writ petitioners were appointed against the sanctioned vacant post is recalled and substituted by the requirement of this order to make a factual verification in respect of the individual writ petition. R. Mazumdar, Learned Counsel, for the review stands that aforesaid access can be indicated and completed within a period of 3 months from the date of receipt of the certified copy of this order. But against that order, they make an inquiry.
Then what happened?
Then, my lord, what happened, my lord? They make a committee, my lord, where there is no order passed by this honorable court in review petition, my lord. They make a committee, and in the committee, my lord, that is page 124. Now 121 in item number 9. They stated that we are not working, we are giving money and we get appointment like that, blah, blah, blah.
Your Lordship,
That is the case. Then this honorable court pass an order that as per review order, whether the petitioners were working as a sanctioned vacant post or not, then they have passed an order and no, no. Then 10/6/2025, they have stated that namely Jiten Gayan, Onin Chandra Gayan, and Hiranya Das, they were already been working as against the sanction post, and now they have to say the remaining petitioners whether they have been working against the sanction post or not. That is my pair. If they were appointed against the sanction vacant post, they have been appointed, madam, as per review petitions. They have filed.
Your Lordship, there is a one order. Your Lordship, instruction, Your Lordship, I would like to please state, Your Lordship.
Okay.
Lordship, paragraph 5, Your Lordship, I would like to read it, Your Lordship. In compliance of HSC order dated 9/8/2025 that was passed in review petition 52/22, the government issued a speaking order number so and so, which was dated issued on 1/6/2024, which rejected the claim of the petitioner, highlighted the fact, Your Lordship, the petitioner, that is Hiranya Das, has again filed a case bearing number 4114/2024 challenging the government wide order dated so and so, which was issued on dated 1/6/2024 in compliance with the HSC order dated 9/8/2022 passed in review petition 52/2022, that is State of Assam versus Ajit Gogoi, stated that the claim of the petitioner cannot be considered as there is no specific guideline trace to be followed for appointment of the petitioners, and in absence of a specific guideline, petitioners were appointed without following any due procedure of law. Further, no such documents are found during the hearing, which was unable to prove that the petitioner were appointed against sanctioned vacant posts, and hence the claim of the petitioner are hereby rejected.
But in the last order, you mentioned that
Yes, Hiranya Das is that is 10/6/2000.
Your
Your
Lordship, this is the order.
Jiten Guhai, Onil Chandra Gayan, and Hiranya Das. Instruction have been received that they were appointed against the sanctioned vacant post.
Your Lordship, Your Lordship, in the last order, Your Lordship, I am not, Your Lordship, appeared.
Say like this.
So, Your Lordship, I will obtain instruction, fresh instruction regarding this. A short date may be given, Your Lordship.
My lord, last occasion Utpal Sharma was appeared, my lord, showing the name of Utpal
So
Sharma.
who is the senior standing counsel here? Who is the senior standing counsel?
Assisty.
SMT 60.
Please call him. Let us find out.
He was not there, Your Lordship, today, Your Lordship, due to some personal difficulties. Your Lordship.
Let the
Short
matter be
date-
listed next week.
Yes, Your Lordship. Next week,
Monday.
any date. We get someone quick
Third.
ambulance.
Counsel to the parties.
On instruction.
The petitioners before this court are agreed that the directions issued by the court by judgment and order dated 9/8/2023 passed in
Monday.
petition 52/2022. Hereby,
Sorry.
the secondary education is directed to examine cases of the petitioners by calling for individual records from the respective schools in which the petitioners were appointed, and to verify as to what was the number of sanction posts in respect, number of sanction posts, respect of the posts where the individual petitioners were appointed, and also to find out whether on the day the appointments were made, any sanction posts were available and if they can stop. The court bench directed that if the answer is in affirmative, it has to be understood that irrespective of the manner of appointment of the petitioner, by the said order, the coordinate bench directed is under para 18, 19, 20, 21 years. There are the respondents in terms of the said order. Where is the rejection order? Page 121
121.
by order dated
First case.
what is the date of the order? 1/6/24. 1/6/24. What is the date of the order?
Order dated, my lord, 1/6,
1/6/24.
yes, my lord, yes, my lord. 125.
1/6/24. Stood rejected. We give the present rejection, right? There are the counsel appearing for the secondary education was permitted to complete practice by the court, more particularly with regard to the issue as to whether there were any, whether the petitioners were appointed in sanction vacant posts. So on 10/6/2022, bench recorded the submissions of the standing counsel, Mr. U. Sharma, that the three persons, namely Jiten Buhai, Kuma Anil Chandra Gayan, and Virendra Das, were appointed in sanction posts. So, further time was granted to complete the instructions. Standing counsel, the matter is called up, Mr. Das, standing counsel, submitted before this court and instruction received from the secondary education, director secondary education, dated 19/3/2026, to submit that there were no sanction vacant posts to which the petitioners were appointed, and accordingly, their pieces were rejected by the impugned order, which is under challenge. So there are these instructions and the information placed before the court as recorded in the order dated 10/6/2026 appear to be conflict. Appear to be contradictory. So accordingly, the permit the standing counsel to clarify before this court as to the status of as to the specific, as to the correct instructions with regard to the position regarding the appointment of the petitioners in their respective posts. We list this matter on how much time you want?
1 week, Your Lordship.
Huh?
1 week.
1 week. 27th. Right.
Yes. Obliged. I'm deeply obliged. Your Lordship.
Wait,
Yes.
let me briefly indicate the facts. Sometimes in June 22, my lord, the petitioner was appointed as a my lord provisional in the All India Institute of Medical Sciences 1. Lord, on 1/8/24, my period of probation was extended for a period up to for a 1 year up to 31/7/25. Then, my lord, before even the period of probation was completed, my lord, on 1/7/25, another extension was given for a period of 6 months, effective from 2nd of July 2025. In the meantime, what had happened, my lord, the petitioner was subjected to, my lord, sexual harassment in workplace. So the institute, my lord, directed constitution of an ICC, my lord, and the ICC report indicted respondent number 6. Now, what the authority did, my lord, instead of proceeding against respondent number 6, they, my lord, did not accept the ICC findings. And, my lord, several coercive measures were taken against the petitioner. So I had to approach this honorable court. Every time I approached this honorable court, some protection or other was given by this honorable court. Now, eventually, my lord, what they did, my lord, instead of taking any disciplinary action against the respondent number 6, who was found to be prima facie guilty of sexual harassment, my lord, they issue an impugned notice of termination on 22/8/25 against the petitioner. I approached this honorable court in this proceeding, and there was a stay order granted. Now, my lord, this matter was pending. Now, most interestingly, my lord, what they did, they filed an order on, my lord, 27/1/26, which your lordships will get at page number 32 of the IA number 260 of 26. Please have that IA, my lord. IA 260 of 26. If I am terminated, that means they have, my lord, by necessary implication, because this honorable court only stayed the order. So it does not mean that they will now, fact that they have issued a posting order, that means I am still in service. Page 32.
32.
Yes. It was on 27/1/26. It is to hereby inform that by instruction of the competent authority, Dr. Nisha Toteza is hereby posted in the Department of Neonatology under Saraswati Tripathi, Professor so-and-so. Now, earlier my termination notice was dated 22/8/25. So, meaning thereby, my lord, the earlier impugned termination notice they have given up. Otherwise, once termination notice is holding the field, merely because this honorable court has stayed it, what is the effect of a stay order? That will not be operative for the time being. It's not wiped out. Now, the fact that you have issued another order during the pendency of the writ petition means their claim over that termination order is no longer there.
Stay order will give you the benefit of service.
No, but that's a different thing. Where is the question of posting me somewhere else?
But you are in service.
I'm in service. I'm in service.
Where is the analogy to draw that merely because there is a stay order, and your service is carrying
What
on by
I'm
virtue of a
trying
stay
to
order,
submit, no,
you shall not be transferred out anywhere.
No, I'm not saying that. What I'm saying is, if the term, they have given up, no, I just wanted to know, Milord, what is the implication of this order at page 32 of the IA?
That is for them to explain.
Exactly. Milord, if we, what I have understood is, Milord, as far as my principal parent in the writ petition is concerned, that stands answered. Now, in the meantime, Milord, what happened? They did not pay my salary. On last occasion, when the matter was listed, this Honorable Court was pleased to direct them to find out whether I have worked. If I have worked, my salary should be paid. Now they have paid the salary. Now the question is, Milord, in the meantime, I have submitted my resignation. I want to get rid of this job, Milord, because I have been through a lot of harassment. Have not only, Milord, sexual harassment, even mental harassment also. So, Milord, I have put in my papers. They should accept it. And they should take against respondent number 6 in terms of the findings of the ICC. That is my case.
Your termination was pursuant to what? Proceedings?
No, Milord. During probationary period.
Probationary.
But that is again, Milord, based on my conduct. It is not a termination simpliciter. So, in nutshell, this is the case, Milord. Take it. Probation order was extended, Milord, 1/7.
Probation for 2 years.
Yes. Provision for 2 years.
Termination within 2 years.
Yes.
So, yes.
In substance, these are the facts, Milord. Subject to
Now
what my learned friends.
your prayer now is to accept your
My resignation.
resignation. Yes.
Milord, there is a development on 17 to 26. After the termination, they have extended my period of probation also. That means, Milord, termination order is not there. Necessary implication. No. Milord, subject to what my learned friends say, Milord, I reserve my right to.
Lordship, may I begin? Before I start on the subject issue proper, I just want this honorable court to bear with me for 2 minutes. Lordship, and the petitioner here, she was an ad hoc employee. She was not a permanent employee of AIMS. AIMS is an autonomous body. Now, a minor workplace disagreement between two individuals was blown out of proportion because she wanted somehow to get permanent. It was brought to the situation that a complaint was made of sexual harassment. As per the rule position, ICC committee was formed. She started targeting the executive director, upon whom neither there was any allegation of sexual harassment, nor he had anything to do with this case. By merely being the executive director, he's a decorated soldier of the Indian Army who on retirement came and joined as executive director of AIMS. He's performing very well as per the general body.
You are representing whom?
I'm representing AIMS. Respondent number 1, 2, and 3.
1, 2, and 3.
Lordship.
Limit your submissions to
Lordship.
respondent
That's
1, 2,
why.
and 3.
That's why I said what has happened. Lordship, this honorable court directed that the executive director would not be a party, or he would not be participating in the general body meetings pertaining to this matter. Fine. The executive director did not appear in that general body meeting also. The general body took a decision to terminate her services, not accept resignation. Not because of this reason that her 2 years period was over or her ICC complaint was false. Firstly, she was an ad hoc employee. Secondly, the thing which they are time and again harping upon, that she was given an extension, she was interposted to neonatal department. It was because a stay order was operating given by this honorable. It was not that at our own we were transferring her from one department to another department, or we were troubling her. Nothing of this sort. Nobody was after her. It is just because an ego issue has been blown out of proportion. And today we are at this stage. Initially, she came to the court to give a stay order on her termination. When the facts were brought to the notice and on the last day of hearing, that is on 11th June, they came out that she has not been paid the salary. We have filed an additional affidavit yesterday. Before the last date of hearing, her all payments were cleared. In fact, she has been given 8 days of additional payment, which is required to be recovered from her. On top of that, before her resignation oblique dismissal can be put into effect, she has disappeared. Today, she is not on our premises. Neither she is coming nor she is working. When the stay order is operating, given by this honorable court, how was it possible for us to not to employ her anywhere? We placed her in neonatal department just to avoid the clash which was going on in between respondent number 6 and this lady. It was not for any other reason that we were employing her. After all, she is being paid a salary of 3 lakh rupees per month plus. She has to be employed somewhere. So we have placed her in neonatal. Now that particular issue that she was posted, hence the probation period was extended. No, Lordship, that is not the factual position. The salary issue which they have raised, we have filed the additional affidavit yesterday. We have not withheld any of her salary. Rather, she has been paid 8 days of additional salary. Now, where is the issue which further allows us to carry on with this petition? All their
What is
grievances.
the challenge here in the writ petition? Essentially, your termination.
Essentially, my notice of termination.
Termination.
Lordship, she was an ad hoc employee.
So we'll examine that matter if you want.
The general body has passed up.
Whatever it may be, there's a challenge made to the termination during probation.
Lordship.
Whether it is termination simpliciter or there are some,
Lordship.
Yes.
it will have some consequential effect. It will
Lordship.
have to be looked into. Now, keep the matter for hearing on a particular date.
As you please, Your Lordship.
Well, only one thing, possibly fix a date is not difficult. My learned friend has made a submission that one fine morning I disappeared. If you also should kindly come to page 80 of the writ petition. Please have clause 3 of the appointment order. I have not disappeared. I have given my notice, 3 months notice.
They are contradicting them.
Your appointment may be terminated at any time with a 3 months notice by either side. Page 80, clause 3. The appointment.
Where is the termination order?
That has been challenged.
That is
Where is the order?
Yes,
Page
I'm
number.
placing it. At page 134.
page annexure 13 at page 130.
Yes.
Annexure 13. Lordship, may I read? Lordship, this is a termination simpliciter.
No, merely because you mentioned termination simpliciter, it's not sufficient to read whether it is simpliciter. You are terminating somebody.
Lordship.
And that somebody, as you have said, is employed at a salary of 3 lakhs. How
Lordship.
many people in the country get a salary of 3 lakhs
Yes,
in
Your Lordship.
government institution? Number one. Number two, the very fact that she gets a substantial amount of money would mean that she is reasonably qualified to render
Lordship.
services. So therefore, to find her services unsuitable, the records will have to reveal what are the
Exactly.
grounds and reasons and why you found her unsuitable.
Lordship.
But we appreciate that as an employer, you are within your rights to terminate somebody on probation. But when the matter is before the court, at least prima facie, we have to be satisfied that it was
Lordship.
because she was unsuitable. She was, maybe she doesn't know,
Lordship,
doesn't have the required.
permit me to explain this. Permit me to explain.
Yes.
Lordship, she is about 40 years of age. Instead of using this dismissal simpliciter, if we start writing here that your services have not been found to be satisfactory, you are professionally not qualified, your performance has not been good, actually it is going to adversely hit her. in
That's
future.
right. Therefore, we want to see your records, which has led to this decision being taken by, I believe, the governing body.
Yes, Lordship, every decision has been taken by governing body.
Right. So
Nothing
we
by
have to
any
go through the records to satisfy whether this is a termination simpliciter. The fine line dividing termination simpliciter and otherwise very thin. Any document, anybody terminate may have a consequence, may not have a consequence. You'll have to see the further consequences, because let us say that whatever you say is acceptable to the court, that she's not suitable, she's terminated. Let us say the person has to go and look for another job somewhere,
Lordship.
right? And if there is a information available before that prospective employer that she was terminated because she was found unsuitable by AIMS,
Yes, Lordship.
one can very well understand the position of getting
That is
fresh
what
employment.
That is what I am
So-
submitting, Your Lordship.
So
We are a
therefore,
model employer. We don't want our ex-employee to be harmed like this. So there was already a stay order operating in this matter. So the governing body decided, okay, let us put an end to this controversy. Let her go. She wants to go. As it is, she's planning to put up a resignation or something. She was an ad hoc employee. There was no question of resignation.
no, the stay order is pursuant to issuance of this particular order, isn't it? 22(8). Interim order by the court
Yes.
is pursuant
Yes,
to
yes,
issuance
yes,
of
Your Lordship.
this.
Yes, Lord. I'm sorry, Your Lordship.
Page 61, Miller, of the IA 260.
Page?
Page 61, that order 17 to 26. Miller. But I think that's why I did not go to all the integrated issues in the case. Miller. All that I submitted was, I have submitted my resignation in terms of my order of appointment. Better accept it and relieve it. And you take action against respondent number 6 as per the decision of the decorated soldier should respect the honorable court's order. The decorated soldier has not
No,
followed the order of the honorable court.
Those
Decorated soldier has got no
those
right.
references are not.
No, what I'm saying is, there was a specific order of this honorable court that Mr. Puranik will not even intervene in my matter, and he has issued the notice of termination.
No,
No,
he has.
that is the official.
That is a governing body's decision.
that,
He's
that
conveying.
has to come through.
No,
It is written for and behalf of
there's
governing
a
body.
judicial order.
Who's
Judicial
the
order.
employer?
Lordship,
No,
I am
judicial
for
order.
number 5.
No,
I am
please.
for Professor Ashok Puranik. Lordship, Annexure 7 clearly specifies 17 clearly specifies Executive Director AIMS Gauhati for and on behalf of the governing body. Now,
There are-
and countersigned by the chairman governing body. So I am doing it in my official role.
In the
This is my
official
duty,
and
capacity,
it is my
you were
duty.
debarred. Please come
No.
to 107. Let us complete one by one.
Barred from appearing in the governing body.
107, Milord. Please come to 107, para 22. When my earlier order of this honorable court.
107.
Yes,
Page
the writ petition is a judicial order, Milord, of this honorable court. Para 22. The competent authority has a lot of.
Yes.
Competent authority is accordingly directed to complete the proceeding expeditiously within the outer limit of 2 months from today. It is further provided that while the competent authority will consider the matter, stakeholders, namely the petitioner and respondent number 6, be given adequate opportunity to represent themselves. At this stage, Sri Gupta, the learned CGSC, has submitted that the OM dated 411 is presently followed. It is needless to say that all actions be taken in accordance with. It is provided that if I'm sorry, Milord, para 20. I'm sorry. Para 20 at 107. Be that as it may, this court is of the opinion that while the impugned communication dated 4/4/24 is held to be unsustainable in the eyes of law, as the same was issued by an authority without jurisdiction, the matter is to be remanded to the appropriate authority to take a call. However, in view of the developments and also taking into consideration the observation made by this court in order dated 3/5/24, 11/12/24, and 14/2/25, it is provided that if the governing body assumes the role of disciplinary authority, respondent number 5 should not be made a part of the same, and his place be taken by any other officer of equivalent rank. So, my lord, that order he could not have signed.
No, that was from the governing body. His place was to be taken by somebody else in governing body. He is only sitting.
Governing body has taken the decision, that I also understand.
So-
But instead of Puranik, some any other officer.
How does it makes a difference?
Lordship,
The
Two
governing body
points.
chairman has signed.
Lordship, 2
Let
points.
us examine the records. Call for the
Number one
records.
point is that he was not a member of the governing body.
We'll examine the record.
Lordship,
We'll have to call for the records and show us what are the reasons why he was found, why the petitioner was not found to be suitable to be retained.
My lord, my humble submission
The
is.
question is very simple.
Yes.
He wants to go with a
It is my
resignation,
term.
not with a termination.
Yes.
As simple as that.
Lordship, I may
She wants to go. She doesn't want to be with you.
Lordship,
You also don't want her.
yes, Your Lordship.
Both are agreed on this point.
Yes.
I wish,
The only thing that none of you are agreeing, or you're unable to agree, is that she doesn't want to leave the institution with a termination order.
Yes.
She wants to go by placing her resignation.
That's why a termination simplicity.
You examine and
My lord,
This-
there is
because-
an earlier order of
because-
this honorable court pursuant to which I submitted the resignation.
but that was loaded with so many things.
The question is that both the parties are agreed that you don't want to be seeing each other in
Got it.
workplace.
As it is, she has left.
She has left otherwise, 22nd. On her own then.
She has not informed us. We don't know where is she.
Well, there is an order of this honorable court of 31/3/26,
Yes, Your Lordship. 31.
where it is clearly mentioned.
No, I will come.
31,
3.
3. 26.
31/3/26. Your lordship should kindly come to third para
In the IA.
in the main repetition. I 260.
Yes.
Today, the rival parties have made their respective submission in brief, and during the course of submission, Mr. Mukuldev, Learned Counsel, appearing for respondents number 2, 3, and 7, on instruction submits that if the petitioner is agreeable to submit an application for resignation solicitor without making any reference to the alleged atrocities committed to her, as was mentioned in her notice of resignation of service dated 21/1/26, the respondent authorities concerned are agreeable to consider her application and place the same before the governing body for its consideration. So this when so appearing for petitioner submits. If that be the case, petitioner is willing to submit a letter of resignation. Simpliciter by 2/4/26.
There's an order of the court.
Yes.
Lordship, I only made this offer on that day. Let us kill this controversy once and for all.
Accept it and
Lord-
close it.
Lordship, I would now request Your Lordship to kindly see that resignation letter which has been submitted.
Page. Where is it? Page number? Where is the resignation letter?
I think page 37 of the IA. 7, That will do.
No, 37 is
Oh,
an
sorry,
order.
sorry, I'm sorry. Oh, rejection order. This is rejection in respect of the earlier letter of resignation. Correct, Milan, but in terms of the last order, they were supposed to bring on record the decision of the governing body on the said resignation. 13/5/26 order, Milan. In the IA. As agreed to by the Learned Counsel for the parties, list this matter for admission after 4 weeks. Respondents are directed to bring on record the decision of the governing body by way of an affidavit.
Where is it? All right, we'll keep it for hearing then. Call for the records. Get the records. Third counsel for the parties. Meetings are exchanged in the matter. Call for the records pertaining to the relating to the termination of the writ petition by the governing body. Decision of the governing body, which is presently on the challenge. Present proceedings. Release this matter again.
August first week, Your Lordship, if possible. August first week, if it is possible.
First week. How about 13th August?
Yes. Lord, instead of 13, could it be, my Lord, 11th or 6th?
All right, 11th.
11th.
11th August.
My Lord, may I pray, my Lord? Since Lordships will be taking up the matter on merits also, maybe, do not know, that sexual harassment ICC report also should be there.
It's not relevant for the
No,
purpose.
it's
Now
relevant.
the
my
issue
Lord.
is over. That issue and salary issue is already over.
Kindly see,
see
no,
that.
kindly see, my Lord, here is a
We
case.
will call for the records if required.
Yes.
If required.
No, my Lord, if your Lordship goes to the merits, then it will be required.
We don't know. The question is of whether it is a termination simplicity or not. We are only examining that.
And
Now-
my Lord,
now
pardon,
for that-
I'll give a brief narration. There was a report by ICC. ICC indicted the head.
All right.
One Mr. My head.
Listen to the order.
Yes, yes.
Matters be listed on 11th August as agreed to by the parties. That the records pertaining to the issue of termination of the writ petition be kept available for perusal of the court if the need so arises. Since the question of sexual harassment is being alleged against private respondent number
No, petitioner. Against private respondent number
6.
6.
And there is also a party respondent here. The records pertaining to the ICC, they also called for and kept available for perusal of the court if so required.
Lordship, that will be made available on that day. But Lordship, that issue is already over.
If so required.
If so,
If so required.
grateful, Your Lordship.
Mr. K. N. Chaudhary, assisted by Mr. S.P. Sharma, appears for the petitioner. Mr. Dev.
Mukul Dev.
Mukul Dev appears for respondent numbers
1, 2, 3.
1, 2, 3. Mr. D.S.
For
Bhattacharya for
respondent number 5.
5. Mr. M.S. Gayan for respondent 4. Mr. Fugan for respondent number 6. Released accordingly.
Well, the interim order, no question, that will continue.
Lordship has already left us. What is there in the interim order?
Will continue the next day.
Yes.
You already left us, Lordship.
You want her to leave?
No, that is fine. You know why they are asking for the interim order? So that subsequently they will say, now you give us the salary also for that period. When she is not working, how will she get the salary?
We'll see about that.
Much
Kindly have a look to the order dated proceed 5/5/2026 was
5.
5/5/2026.
এবার রেডি করো আছে না খবর না খবর দিও যদি আছে 5 মিনিট কেন yes
5/5/2026. Thereafter, Lordship, they took time on subsequently on 2 occasions.
what is your prayer
My matter relates to promotion from grade 4 employee to grade 3, that is junior assistant Lordship in a school Lordship. And
as per direction of the division bench of this honorable court lordship, they have lordship frame a rule, but if the rule is silent the procedure how the promotion is to be made, and to that effect lordship the director submitted proposal to the government for amendment of rule that they have lordship stated in their affidavit. The document has already been placed.
Also, Manju,
Case 91.
so amendment has not been done.
Amendment, no, the amendment has not been done. This can the
Now, Lordship, after filing this writ petition, the government has amended, before filing this petition, government has amended 2003 rule, Lordship, 18 rule, Lordship, by incorporating the provision for promotion from gate 4 to gate 3 also. But
10%.
yes, but rule was not framed, Lordship. And after filing this writ petition, Lordship, one proposal was noted from the DAC, Director of Secondary.
Government has amended what?
The rule of 2018, Lordship.
But then why do you say rule was not formed?
The idea, Lordship, rule was, that provision was not there.
I know, but subsequent
Yes,
amendment
but
it is
subsequent
there.
has a problem. Now let's see that process of filling up the promotion now has been incorporated and now cabinet on the last cabinet on 5th of June 2026 has approved that proposal also. So that department
Is there a set of, what are the rules? Provincialization.
Lordship, Assam Secondary Education Provincialism School Court Amendment Rule 2024 has been amended. That as per that rule, there is a provision incorporated from promotion from grade 4 to grade 3. Lordship.
That rule has received, that rule was notified when?
Case 28 lordship, 7th October 2022. Case 28.
28. October 24.
24.
Then
Now, but that rule provision has been made, but the process of the selection, promotional procedure has not been prescribed in that rule. For that, Lordship, further amendment has been made, Lordship. In that respect, Lordship, Cabinet has also given approval on 5th of June last in the Cabinet. Now, process is going on, Lordship. The department, I have just talked with department, it will require some further time, Lordship, at least 8 weeks, Lordship, to bring everything, Lordship.
what do you say?
Sometime.
No, is it your case that these rules at page 28 amendment are sufficient to proceed for filling up?
But although some step is taken by the authority for the selection and promotion, but they have not completed because due to lordship lack of this procedure.
So procedure has to be there.
Has to be there.
They say that it has now been approved.
So some
Heard Mr. M. Khan for the petition and Mr. TP Doctor for the respondent. What is this? Higher education?
Secondary education.
Secondary education.
School education.
Submitted that recent cabinet approval has been received in respect of the procedure frame of filling up for the post of junior assistant from the feeder category of grade 4 employees at the school. In
By a
terms
promotion.
of the amendment of Rule 5 brought in by notification dated 7th October 2024. Submitted that the process required to be adopted by the state for filling up of the post in terms of the amended Rule 5 is underway. However, for effective implementation, further time of 8 weeks is prayed for. Council for the petitioner submits that the cabinet has already taken a decision. All steps should be taken by the department in the right earnest at an early date, considering the submissions, release this matter again. 28th of August, by which date the state will apprise the court the status of the process undertaken for filling up of the posts, filling up the posts of near assistant from the
Grade 4.
feeder category of grade 4
By a
by way of promotion. Released it accordingly.
obligation.
Yes, Mr. Roman. Malo, why are you hanging on to 2014?
Lord, actually, this matter is pending,
Right.
and there's several occasions, the respondents took time for the change of counsels for some other reasons,
What is your grievance here?
The grievance is that, I was a person, who had participated for the post of the regular principal, Subsequently, I had been selected and appointed. Now, my dad's selection and appointment had been put into challenge before this honorable court, and this honorable court, while upholding my selection and appointment as the principal of the college, did not interfere with the same, and directed the director of the higher education Assam to examine the list of the eligible teachers for the purpose of provincialization and also to pass an speaking order, and accordingly, in the initial speaking order was passed, but nothing has been held that whether I can continue in the post of the principal or not. And accordingly, then again I have to come before this honorable court, to file a fresh writ petition, that
No,
the
why you can't continue?
Milord,
Why the question of whether you can continue or not was raised?
no, this honorable court, while relegating the matter to the director, has held that as the interim order was operating, restraining me from functioning as the principal, till the director take a decision, for the purpose of claiming the seniority or passing and speaking order. Till then, I was restrained by this honorable court, But once the speaking order is passed, the director, ought to have taken a decision by allowing me or rejecting me, but that has not been done. So, therefore, I had to again approach before my lordships, that the decision has not been taken.
Where is the order of the court directing the respondents to take a decision?
Yes, my lord may be pleased to find that order, my lord. WC 4073, my lord. Yes, my lord, it is. My lord may be pleased to find the operative part, my lord, that page number 88, my lord. 88, my lord. Paragraph 28. Paragraph 28, my lord. May I read, my lord? Having heard to the above, court, having regard to the above, court is of the view that the Director of Higher Education Assam should now take a decision on the above staff list of the Borkhetri College dated 19/12/2011. The Director shall apply his own mind after consulting the relevant record without being influenced from any quarter. The court has been compelled to sound that the said note of caution considering the order sheets of the present proceeding reflects attempts of extraneous interference at the various times. Therefore, it is necessary that the director should insulate himself from all such influences and take a decision based on his own assessment in accordance with law. Such decision shall be taken with a period of 2 months from the date of receipt of a certified copy of this order. Any restraint order to this effect would stand modified accordingly. However, the stay order passed by this court restraining MD Lokman Ali from functioning as the principal of Borkhetri College would continue to hold the field till completion of the above exercise by the Director of Higher Education Assam and would be subject to such decision that may be taken by the director. So,
You are the petitioner.
I am the
You
petitioner.
are Lokman Ali.
I am Lokman Ali.
You are holding the post of a principal.
Principal.
Borkhetri College.
Borkhetri College.
Then what happened after this order?
Milord, after this order, Milord, we made a representation bringing into the knowledge of the director regarding this order, Milord, and the director accordingly, Milord, passed an speaking order. My lord may be pleased to find that speaking order starts at page number 99, annexure 16. Milord. My lord, this is the speaking order by which the entire seniority list, my lord, as well as the eligibility of the, my lord, the incumbent concerns who were working at the college at that relevant period of time had been fixed. And my lord, may be pleased to find that page 103 is the detail of those staff, my lord, from serial number 1 to serial number 43 in the tabular form, who are eligible to the post for provincialization, and the seniority had also been fixed, my lord. But the very core issue regarding, my lord, that the my continuation and whether I am eligible for the purpose of continuation in the post of principal or not had not been fixed in this speaking order, my lord. And accordingly, therefore, my lord, I did again approach, my lord, before this honorable court, my lord, for the taking a decision on the direction as well as my representation regarding my fate. My lord, this honorable court was pleased to dispose of my representation, my lord, is at page 106. Starts, my lord, can skip, my lord. The operative part is at page 107, my lord. And my lord, in view of the above, this writ petition is disposed of with a direction to the Director of Higher Education Assam to dispose of the representation dated so and so filed by the petitioner by a speaking order within a period of 1 month so and so of a certified copy of this order. While disposing of the representation, the selection process undertaken by the governing body of the college shall also be considered. With the above observation and direction, this petition came to be disposed of. Now, my lord, this impugned speaking order is at page 109. Annexure 18, my lord, came to be passed by the Director of Higher Education. My lord, the entire facts has been, my lord, narrated that how the selection has been, records has been, my lord, may can peruse from. My lord, the honorable court by the aforesaid order has been held that the stay orders in restraining MD so and so from functioning of the principal of Borkhetri College would continue to hold the field till the decision of the established is made within a period of 2 months, and such restraining order against MD Lokman Ali would be subject to the such decision that may be taken by the director. Meanwhile, subsequent order dated has been passed by the Honorable High Court that no decision is taken to the direction in the above para 29 of the order of the Honorable High Court dated so and so. The Honorable High Court accordingly directed the DAC Assam to dispose of the representation dated of MD Lokman Ali. The representation of MD Lokman Ali and records have been perused, and those records revealed that an advertisement was published in the Assam Tribune on its issue dated so and so made by the Secretary of the Governing Body of the Borkhetri College in inviting application for the post of principal. The selection committee was constituted by notification dated so and so. The interview was held on so and so. The selection committee recommended 3 candidates in order of merit as MD Lokman Ali, Dr. Mamoni Bhattacharjee, and Dr. Jahirul Haq. The governing body thereafter adopted resolution number 2 had resolved that MD Lokman Ali be appointed as a principal, and also resolved that the appointment letter be issued accordingly. The president of the governing body on the said day itself has issued appointment letter in favor of MD Lokman Ali, and MD Lokman Ali thereafter submitted his joining report on so and so. The Honorable High Court by order dated passed in WPC number was pleased to suspend the action taken on so and so in favor of MD Lokman Ali.
Who is challenging that writ petition? Who filed the writ petition?
My lord, some of the persons, my lord,
Who were not selected.
who did not, who was not selected, as well as, my lord,
And it is in this writ petition that the interim order was passed that you will continue till decision is taken.
My lord, in their writ petition, my lord, not in my writ petition. So therefore, my lord, situated thus, the Assam Venture Educational so and so be 2011 has came into force. This section 2 which may be quoted as follows. Section 2 which employee means and includes all serving employees, both teaching and non-teaching of so have been appointed by the concerned venture educational institutions before the first day of January 2011 and whose services are being or would be provincialized under this act. By virtue of above provision of the case, MD Lukman Ali may be treated as an employee of Borkhetri College before 1/1/2011 as assistant professor and all purpose of provincialization of services of MD Lukman Ali are to be made as assistant professor only due to his posting as an assistant professor in Borkhetri College before 1/1/2011. The aforesaid selection of MD Lukman Ali obviously after 1/1/2011, that is on so and such selection in no circumstances be provincialized as a principal as per provision of section 2H of the so and so Act. The selection after 1/1/2011 cannot be taken into account to manage the affairs of the college where the services of the Lukman Ali processed as an assistant professor and not as a principal by near of aforesaid provision of law. Therefore, the selection of MD Lukman Ali as a principal cannot be made.
What is the rationale?
Lord, from the MP.
After the 2011 Act was
Mal.
brought in,
Mal.
the petitioner is treated to be an employee under the Act,
Mal.
serving as an assistant professor.
Mal.
Then
My lord, the ratio which the director my lord tried to fix, my lord, is there. And my lord, from my limited understanding, my lord, what I beg to submit is that, my lord, as the petitioner had been appointed as a principal on 4/6/2011, so therefore, my lord, he is the my lord, crossed the cutoff date. That is, the cutoff date has been fixed on 31/12/2010 as per the statute of 2011. For the
cutoff date for what?
Cutoff date for provincialization of the employees working in these categories of venture institutions, my lord, who were appointed before 31/1/2011, that is 31/12/2010. Those employees can only be provincialized as per the view taken by this speaking order, my lord. That's why, my lord, they do not want to give me the benefit of provincialization as a principal. Rather, they have provincialized me as an assistant professor, my lord. That is admitted. Because, my lord, in this college, I had been working as an assistant professor.
What is the process under the 11 Act for selection, the post of principal?
My lord, there was no process had been, my lord, earmarked or fixed, my lord. The open advertisement is made, my lord. And as these are the venture colleges, my lord, at that relevant period of time. So, my lord,
in your case, it was prior to the Act of 2011.
Prior to the Act of 2011, my lord. Because the advertisement which has been made, my lord, I have also annexed the advertisement also, my lord. My lord may be pleased to find the advertisement basing on which I had been appointed is at page 36, my lord, on 25/5/2011.
Now, what has happened to that? Who has passed that order of your selection as a principal?
My lord, the governing body of the college.
Governing body.
Governing body.
Was that ratified by the department?
No, my lord, what has happened, my lord, before the provincialization, the governing, my lordship knows, my lord, the governing body was the authority to take up the recruitment exercise, and accordingly they have taken up, my lord, even this advertisement had been issued pursuant to the order passed by this honorable court, my lord. So thereafter, I, along with some other, my lord, eligible candidate as per the advertisement did participate, and my lord, in the merit assessment, I stood first. That's why, my lord, I had been appointed. Now, they are saying, my lord, that as my appointment is beyond the cutoff date, so therefore I cannot be provincialized, my lord. Now, my lord, my stand is that the stand taken by the director is contrary to the statute as well as the various provincialization, my lord, exercise taken up in the entire state. Similarly situated principals, my lord, who were appointed after this cutoff date.
What is the act?
My lord, may be pleased to find the provision of the act, my lord, in this book, my lord, is at 648, my lord, page number. Because, my lord, this was done under the earlier Act of 2011. My lord, here I am referring to the definitions, the employees, my lord. Page number 649, section 2, clause H, my lord, the employees. But it says that the means and includes all serving employees, both teaching and non-teaching of the venture educational institution who have been appointed by the concerned venture educational institutions before the first day of January 2011 and whose services are being or would being provincialized under this act. So, my lord,
Your appointment as a principal was on which day?
4/6/2011. That's why, my lord, they are saying that it is beyond the cut-off date. Now, my lord, the employee, if my lord, if we go by the definition of the employee, it is not, my lord, connected with the post respective. It says that the employee, the existence of the employee should be in the particular institution, my lord, in a particular post, my lord. Now, I was working in that institution since 1994, my lord, as an assistant professor in the Department of History, my lord. So therefore, my connection as an employee, my lord, starts from the year 1994. Now that's why, my lord, my past service as an assistant professor will automatically come and merge with the appointment as a principal, my lord, that to give the benefit of employees, which the department has, my lord, given the same benefit to other, my lord, employees in other colleges and, my lord, institutions also, my lord.
Now,
Mal.
after you're provincialized,
Mal.
regarding your appointment or promotion, the post of a principal is governed by which set of rules?
Lord, at that relevant period of time, Lord, when I was
No, after provincialization.
after provincialization, Lord, the UGC regulations, which is prescribing, Lord, that will govern the rules, Lord, because I will become an employee of a provincialized college.
There
But
must be a set of state rules.
No, Milord, what has happened? Those employees, the Milord, at the time of provincialization, Milord, in these categories of institutions, Milord, when the advertisement was made, Milord, there was no any such rule the governing body or the such venture colleges in the state did follow, Milord, and that's why my lordship knows, Milord, the statute of 2011 had been set aside by this honorable court that treating that there are certain lapses in the act, Milord, and that's why it had been, Milord, set aside, holding the same to be an unconstitutional act. So now, Milord,
this is what a college.
This is a college. This is a college.
Is it an aided college?
No, Milord, this is this when
after provincialization, what is the status?
Status, Milord, it will become the other similarly situated as like the other provincialized colleges, Milord. Because, my lord, my contention and my respectful submission before my lord is that, my lord, as the similarly situated principals in the entire state had been would be provincialized, my lord, by following the same set of, my lord, procedure and statutes, my lord, I had been sidelined only relying on the issue of my cut-off date, my lord. My lord, I have annexed certain documents in my writ petition, my lord, from where my lordships may be pleased to find that, my lord, similarly situated principals, my lord, who were originally appointed, my lord, as an assistant professor in their respective colleges, subsequently, my lord, they have been promoted or, my lord, upgraded in the post of principal after the cut-off date, and, my lord, they were provincialized. Only, my lord, this person, my lord, MD Lukman Ali, my lord, had been sidelined by the department by treating the cut-off date is a bar for me, my lord.
Where is the order of your appointment?
My lord, yes, yes,
As the
my lord.
principal.
My lord, the order of appointment, my lord, may be pleased to find is at page number, my lord, 40. Is my the call letter, my lord. Then my lord, may kindly turn to page 42. My lord. The undersigned has here highly pleased to inform you that as per the resolution number 2 of the governing body held on 4th of June 2011, you have been appointed as a regular principal of Borkhetri College, Mukalmu. You are hereby requested to join on your duty within 7 days from the date of the letter. My lord, responding to this appointment order immediately at page 43, my lord, annexure 7, I did join. The original, my lord, acceptance is at page 44 also. Now, my lord, this appointment had been put into challenge in the, my lord, order which I have brought into my lordship's kind notice, my lord, just now, wherein, my lord, my appointment had not been interfered with by this honorable court, and the order had also not been put into assent in any higher forum by the aggrieved parties.
This was challenged in WPC 4073.
Yes, yes, my lord.
And there is an order of 10/8,
uh,
2011.
no, my lord, in WPC, the final judgment has been passed on 9/12.
So let us see page 46. 46.
Page number 46, my lord. Yes, yes, my lord.
This is
Yes, yes.
This is the initial order in the writ petition where your appointment was challenged.
My lord, this was the interim order passed, my lord. Subsequently, series of writ petitions were filed and all those were clubbed together.
No. So
Yes, yes.
You're trying to understand the sequence of
My
events.
lord.
So by this order 10/8/2011,
My lord.
where your appointment as a principal was under challenge,
My lord.
there was an interim order not to allow you to function.
Exactly.
And
Yes.
the interim arrangements to be made by the department.
My lord.
Right?
My lord.
So this continued till the matter was disposed of.
Disposed of.
And when disposal, it was held that you will be allowed to function.
Because my appointment had not been set aside, my lord, only at paragraph 29 at page 89. I am again, my lord, troubling my lordships, my lord, at page 29, page 89. However, the stay order passed by this court restraining MD Lukman Ali from functioning as the principal of Borkhetri would continue to hold the field till completion of the above exercise. So that exercise had culminated into an speaking order, my lord, wherein my case had not been considered. Thereafter, my lord, I again came and this final speaking order had been passed, wherein now the issue they have raised, my lord, that as I am out of the cut-off date, so my provincialization cannot be done, but my lord, they have upheld in fact my selection and appointment.
Where?
Because my lord, they have not said that my selection and appointment is illegal or set aside or cannot be acted upon. Because my lord, in paragraph, lord, in paragraph,
you're putting to challenge the order at 109.
my lord, the speaking order by which my lord, this cut-off date has been now, they have said cannot be, my lord, treated as a valid cut-off date.
This is clear from the last paragraph of page 110.
No, that is correct, my lord. They have said that the aforesaid selection of MD Lukman Ali, obviously after 1/1/2011, that is on 4/6/2011, and such selection in no circumstances be provincialized. My lord, they have said that provincialization cannot be done, but that my selection and appointment has not held to be invalid or vitiated in law. Only they have said that my provincialization cannot be done because of this 4/6/2011. It ought to have, my lord, 31/12/2010.
No,
as
then you
per
read
that.
the next line.
My lord, if as a principle as per provision section 2H of the Assam So and So Act of 2000 Act, the selection after 1/1/2011 cannot be taken into account to manage the affairs of the college where the services of the Lukman Ali processed as the assistant professor and not as a principal by near of aforesaid provision of law. Therefore, the selection of Lukman Ali as a principal cannot be made. The selection of MD Lukman Ali as principal cannot be made. But my lord, only this issue has been raised, my lord, in the speaking order regarding provincialization. Because, my lord, once this honorable court has not interfered with my selection and appointment, so the director cannot, my lord, override the, my lord, judicial pronouncement which has been made in this common order 9/12/2018, my lord. My lord. So my contention, my lord, is that similarly situated principles, my lord, if my lord, I am troubling my lordship with only few annexures, my lord. My lord, may I kindly turn to page number 116, my lord.
116.
116, my lord. This is name of the college, my lord. This is Bangtoli College, Bengal. Bengal. My lord, this is in the Sirang district. My lord, may be pleased to find that this Ranjit Bosumatari, my lord, in the remarks column we have made 1/1/2011 he is joined. So similarly, my lord, if we go by the right hand column, all these persons, my lord, who had been provincialized under this 2011 Act came to be joined after 1/1/2011. This tabular format, my lord, in the various districts. This is first, my lord, Sirang, Dhubri, Dibrugarh, then Golaghat, then, my lord, Dorong, and now the, my lord, the issue of principal, my lord, may be pleased to find at page 140, my lord. 140, my lord. I am referring to one principal, my lord. In exercise of the authority confined under so and so, my lord, this provincialization has been done in respect of, my lord, Dr. So and so, principal, date of joining, my lord, my lord, have found it at 3/8/1992. Actually, my lord, this incumbent had joined in this college as an assistant professor, which my lord can verify this statement from the next annexure, my lord. At page 141A, my lord. I'm just citing some of the examples, my lord. This is to certify that Pradeep Kumar Kolita, this is, my lord, pertaining to Samaguri College, wherein, my lord, Dr. Lunamuni Bora has been provincialized as a principal, though he had been appointed after, my lord, 2012. This is to certify, my lord, to verify this, I am referring to page 141, my lord. This is a certificate issued by the Samaguri College, my lord. This is to certify that Pradeep Kumar Kalita had been serving as assistant professor in the Department of Assamese since 1991 to 2001 and as a principal in charge since 2001 to 30th of October 2012 at Samaguri College, Nagaon, Assam. Now, my lord, this Pradeep Kumar Kolita, my lord, had been relieved from the charge of the office of the principal from 2012. And this Dr. Lunamuni Bora, my lord, came after 2012, my lord, and but her initial date of joining has been counted from the date of her initial appointment as a, my lord, assistant professor.
When was the selection completed?
My lord, this Lunamuni Bora, my lord, it ought to have after 2012, my lord, because this
It's not
incumbent.
clear.
No, my lord, it is not clear here.
Not clear. Whether it was before 2012, 2011 or.
No, my lord, because if this incumbent is holding till 30th of October 2012, my lord, then obviously selection is required to be held after 2012, my lord. This is another example, my lord. And my lord may be pleased to find the next page is, my lord, I am referring at page 145. My lord, here Dr. Rina Rani Bordoloi, who had been working as a provincialized as a designated as a principal, my lord may be pleased to find that 17/4/1993 as a lecturer, date of joining, 13/1/2005 as a principal. Obviously, my lord, her here in this case, my lord, it is before 2011, my lord, but I want to show, my lord, that this 1993 has been treated as the initial date of her appointment as a lecturer. Exactly, for the same set of employees, is at page 147. Dr. Rina Rani Bordoloi, and date of effect, date of joining has been shown as 17/4/1993, date.
So you're saying that in cases of other similarly
My lord,
situated
this their initial date of appointment and joining for the post of assistant professor had been counted. Now, my lord, in this college, my existence is not on 4/6/2011, my lord. My existence is long back as an assistant professor. My lord, may be pleased to find my original appointment.
So there is no quarrel on that.
My lord. So therefore, my lord, my respectful submission before my lord is that the act, if we go by the provision of the section 2H of the, my lord, meaning or the interpretation of the act, my lord, they have interpreted for the other employees in a different manner, and for me, my lord.
Was there any appeal against the order?
No.
By which the direction was issued?
No, my lord. This single judge's order, my lord, honorable single judge's order has never been assailed, my lord. Never been assailed. It has already attained
And
finally.
the person who assailed your appointment,
My lord.
are they parties in the present proceeding?
No. No, my lord. One impeachment had been done by Dr. Mamoni Bhattacharjee, my lord. But, my lord, they are not, my lord, actively participating thereafter, my lord. This impeachment petition is also part of the record, my lord. My lord. One miscase, my lord, in this petition was filed long back for impeachment of Dr. Mamoni Bhattacharjee. He accordingly impeached also, but never, my lord, turned down thereafter, my lord.
What about the state? Have they filed their affidavit?
State has filed one. Detail दिया नहीं. मान वाले बोले तो लोग. We have not, my lord, because I have given. So, my lord, my preliminary, my lord, argument is in that line, my lord, that as I fall within the cutoff date, my lord, as an employee. So, my lord, my benefit of provincialization cannot be denied by showing the cutoff date because my selection and appointment had been upheld by this honorable court. Similarly, situated employees, my lord, have been given such benefit, my lord. Recently, one librarian been given such benefit, my lord, has been directed by one of the coordinate bench from the court, my lord. One affidavit has been filed by the governing body, my lord. Period of time. That affidavit is here, my lord. They have, in fact, reiterated that I was a candidate of, my lord, fair selection, my lord.
is holding the post of the principal now.
My lord, in the meantime, my lord, when this petition was pending, a selection has been undertaken, my lord, and in that selection, one incumbent was appointed. Subsequently, my lord, he left also by giving resignation. Now, at this moment, the post is, my lord, falling back.
What is the criteria for selection post of principal?
At this moment, my lord. At this moment, my lord, we have to go by the UGC regulation and other laws which are applicable.
The whole issue,
My lord.
whole dispute regard to your appointment is in respect of a staff list.
That I had given appointment to some.
No, the list, staff list dated 1912,
My
2011,
lord.
where your name appears at serial number 7.
Yes, sir, as an assistant professor.
Right. So, is it on the basis, is the promotion to be effected on the basis of seniority
No.
or merit?
It is a, my lord, my appointment was a direct recruitment.
Direct recruitment
As a principal, my lord.
as a principal.
My lord.
Then what is the staff list about?
Staff list
1912?
about, my lord, that is the issue. Director has committed a, my lord, an exercise which they have taken. Basing on, my lord, the series of writ petitions have been filed, my lord, and when this honorable court decided all the matters, directed the, my lord, Director of Higher Education to make a consolidated seniority list and the eligibility of the teaching staff.
Please come to page number 88.
Why?
Para 27.
Yes, my lord. Whatever may be the grievance of the rival parties, the fact remains that the same has now crystallized in the form of the staff list dated 9/12/2011, finalized and forwarded by the inserts college principal to the Director of Higher Education, Assam.
What is the staff list about?
Lord, staff list about my lordship knows, my lord, the provincialization staff pattern which are required to be forwarded to the district level committee then state level committee, my lord.
What is this staff list, or how is it relevant for your purposes?
No, my lord. The staff
as
list,
recruitment to the post of principal.
no, my lord, it is no relevance, my lord, with the post of principal. That's why.
You were not a staff of the Borkhetri College.
I am the staff of the Borkhetri College as an assistant professor.
Assistant professor.
My
So therefore your name appears in
at serial number 7.
7 of
My
that staff list.
Exactly.
So now the governing body has made a selection.
Selection.
On what basis?
Selection, my lord, on basis of an advertisement, my lord, which I have brought into my lordship's time.
Where is that advertisement?
Yes, my lord. It is at page 100 and page 36. Also the one in two papers. 36, 38 and 39. Same advertisement in two vernaculars, my lord. Page 36 says, my lord, applications are invited for the post of principal, Borkhetri College, non-deficit, non-provincialized from the eligible candidate selected by the State Selection Board Assam. The candidates having the latest UGC norms with PhD and 15 years of teaching experience of an affiliated degree college may also apply. The candidates having administrative experience will be given preference. Application with the full biodata and attested copies of the necessary testimonials will be received by the present governing body, Borkhetri College, Mukalma, Nalbari, with the 7 days from the date of the advertisement of which salary negotiable. So, my lord, responding.
Now, where is the governing body resolution? Is it available?
Governing body resolution is not available, but my lord can verify it from the affidavit filed by the governing body.
Does not contain the.
No, my lord, I don't think so. They have not annexed it. No, my lord, it is also not a part of the affidavit filed by them also. Lord, what my respectfully beg to submit, my Lord selection and appointment as a principal had been completely tested by this honorable court, my lord, in the series, in the judgment delivered, my lord, in the common
Court
judgment.
did not answer that issue.
My lord.
Court did not answer that issue. Court did not go into the aspect of correctness of your selection by the governing body pursuant to the promulgation of the 2011 Act. There was no finding by the court.
No, that is, my lord, I am not,
Court has,
my lord.
therefore we had drawn your attention to page 88.
My
It says that the dispute crystallizes into the staff list.
My
And then the matter was sent to the director. Right?
The director has also not said me that my selection and appointment is not valid or incorrect. Findings.
Who appears for the governing body?
Well, I am appearing for the governing body. But basically our case is on 2 points. First of all, he doesn't have the qualification to hold the post of principal.
But you selected him.
That was a wrong exercise undertaken, my lord. But ultimately it appeared during the subsequent exercises that his degree was fake. In fact, there is a PRC case registered against him in which a charge sheet has also been submitted.
So where are your resolutions?
Now, that resolution was not made part of the record. My lord, if your lordship permits me, my lord, I can bring it on record. But he said,
Produce the records and
the
show
case-
us for our satisfaction what decision you have taken.
that reason, my instructions are that, my lord, at that point of time, it was in his custody, those resolutions. But subsequently, my lord, the case has a checkered history in the sense that it has been continuing from 2006, 2007. And his persistent effort was to somehow secure the post of the principal. Now, it appeared to have.
What is his position today?
He has been assistant professor in history.
Assistant professor.
Assistant professor in history. Our basic case is on 2 points. First of all,
you say his degree is
his degree phase.
what degree?
The degree of PhD, which he has submitted.
PhD.
And that was one of the consideration in the advertisement
Did
also.
you take any proceedings against him in his capacity? as
So,
assistant
Bala, the governing body had lodged an ejahar with the police and a criminal case is underway. Charge sheet has been submitted in that case. He is facing trial in that case. Now, the other aspect of the matter is that although, my lord, it may not have been stated in so many words in the order passed by the Director of Higher Education that his inclusion in the list of selected candidates was per se illegal. It may not have been said in so many words, but the effect is that because your appointment post the coming of the Act of 2011 makes it very much clear that your service cannot be provincialized. And if your service cannot be provincialized, you cannot go and hold the post of principal in a provincialized college. Apart from the fact that regardless of whether your certificate is fake or genuine, my lord, since it is by operation of law that you cannot enter into the stream of provincialization.
What is that Provincialization Act?
That-
2011.
Yes, 2011. So it laid down a cut-off cut-off date that before which, my lord, the services were to be provincialized or the proposal for.
This is the venture educational institution.
Yes, in fact, this college was initially an institution of that kind. And at the relevant point of time, he was the secretary of the governing body. So everything happened in his own tune. Now, later, when the positions changed, then the things started coming out of.
Came into effect on which date?
2000. It was published on 5th of September 2011, but the effect was
From the date it is notified in the official gazette. As per section 1(3).
no, by notification in the official gazette, appoint and different dates may be appointed for different provisions of the Act. So it came into effect sometimes in 2010.
It was published on 5th of September 2011.
Yes, it was published, but the effect was given from December 2010. Well, I'll just check and come back. So his case admittedly falls beyond the cutoff date. There is no dispute. It is also not disputed by him.
But these are issues not examined by the director.
No,
There is
director
no
has said, director has gone merely on the basis of the cutoff date, that your appointment is beyond the cutoff date not provincialized, hence you cannot be permitted to hold. That is
That is not the order of the director.
My lord, I'll try to read it out to your lordship, my lord. If your lordship will kindly come back to page 109. The operative part is at 110. I'll read from the last paragraph in page 109. By virtue of the above provision, the case of so and so may be of so and so before 1/1/2011 as assistant professor, and all process of provincialization of service of so and so are to be made as assistant professor only due to his posting as an assistant professor in Gauhati College before 1/1/2011. The aforesaid selection of so and so obviously after 1/1/2011, that is 4/6/2011, and such selection in no circumstances be provincialized as principal as per provision of section 2H of the Assam Venture so and so Act. The selection after 1/1/2011 cannot be taken into account to manage the affairs of the college, where service of so and so be processed as assistant professor and not as a principal by near of the provision of law. Therefore, the selection of so and so as principal cannot be made. So the eventual resolution is that since your service as principal cannot be provincialized for the reason of it being beyond the cutoff date, so you cannot be permitted to hold the post of principal. It may not have been worded in that way, but the meaning that I can generate out of it is this.
You can't generate a meaning anymore.
No, my lord,
reflected.
My lord, it is the play of the cutoff dates only, my lord, which has been reflected in this paragraph.
But
his emphasis is on the cutoff date, my lord.
Anyway, that is for the state to
Yes, that they will say. But our case is that, my lord, his certificate, basic qualification which is required, the advertisement page 30.
Show us from your resolutions that how you selected him, what happened. Your party is in the litigation all along.
But
has any ever been made that his basic degrees?
In my affidavit, my lord, in the affidavit filed by the governing body, my lord, that there is a categorical assertion on that point. If your lordship will kindly.
That assertion be an assertion unless there is a finding by an
No, my lord,
authority.
My lord, the matter.
Only the UGC can decide.
My lord, the falsity of the certificate is a subject matter of trial in a criminal case. The falsity of the certificate, my lord, the trial is pending, my lord. We cannot.
That is give them a caveat to say that if they are acquitted, then you are restoring his services with retrospect.
No, my lord, there is also, my lord, although we had filed an affidavit on this point that the prima facie certificate is forged and there is a criminal case pending, there is no counter on that point from the petitioner's side. It's a categorical stand, my lord. Your lordship will kindly see page 8 of our affidavit.
So, but the obvious thing to do would be to get a clarificatory from the institution. Is it a case that that there was no certificate issued by the institution, or is it a case that the certificate issued but the institution's degrees are not recognized by UGC?
My lord, the charge sheet says, my lord, I cannot go beyond what has been mentioned in the charge sheet. Charge sheet says that by accused person showed that he had obtained a PhD degree from Magadha University, Goa. During the inquiry officer found that the PhD degree certificate which was obtained by the accused person was fake. He also collected the report from the Magadha University authority that the accused person had not done any PhD degree course from their university. That is the reading. That is the assertion in the charge sheet. During inquiry, it was also found that the PhD degree certificate which was produced by the accused person, Mohammed so-and-so, was fake and forged.
It's a charge sheet.
That's a charge sheet, my lord. My lord, we are also saying that prima facie, my lord, we don't have any means otherwise to prove that the charge sheet is.
You have the means to go and
yes,
connect with the university.
Yeah, one thing is that, my lord, we could have proceeded against him departmental.
Not could have, you should have.
No, that was an option.
You are the governing body, you should have. Somebody files, and who has filed the FIR?
FIR was lodged by one Sheikh Mubarak Hussain.
Who is he?
He was a member of the governing body, my lord, at that point of time.
How did he get this information? What basis? Has he filed it on his own? Has he filed it
on
behalf of the governing body?
He filed a report. He filed a complaint before the vigilance cell, CM's vigilance cell. Now, CM's vigilance cell then caused an FIR to be lodged. It was on the basis of, the FIR was lodged on the basis of Deputy Superintendent of Police, CM Vigilance Cells representative who lodged the FIR in the year 2020. There was complaints, my lord, all around. Matter went up to that vigilance cell, and thereafter, my lord, the FIR was lodged.
What is the stage of the criminal proceeding?
It is at the stage of appearance of the accused.
And what does the government say?
Yes, I have no instruction to the lawsuit. Otherwise, lawsuit regarding the issue of the principal lawsuit, it was already decided by the Honorable Court lawsuit. Honorable Court directed the petitioner to lawsuit appear in the regular selection process.
Where, by which order?
So that order I placed at 2 p.m. In another round of litigation lawsuit, petitioner is directed to appear in the regular selection process. When he has challenged the lawsuit regular selection process.
Follow up again at 2 p.m.
My colleague S. Das will be there also, he will place the order. Alright.
In the next item, item 35, emergency was expressed, my lord, this is medical registration matter.
We'll take it up.
My learned colleague, however, says that.
My lord,
some
as
instruction-
per lordship specific direction, we have communicated the same to the, my lord, the National Medical Commission. The board is presently sitting, my lord, and is in due process, my lord. During the course of the day, it will come to me. So if he is, my lord, okay with it, we can take it up tomorrow, my lord, if lordship permits.
Tomorrow,
Won't take long, should not, my lord.
we'll follow it up at the end of the list and wait for the, get your instruction. Right? When is the selection or
My
what,
lord, 21st is the last date for application for
which is on Tuesday?
Tuesday.
You can have it on Monday.
So, my lord, before that, if your lordship directs, my lord, the Assam Council of Medical Registration has to sit and they have to issue the registration.
What can be done?
Tomorrow,
Tomorrow we don't know.
If the instruction is clear, my lord, it will not take time, my
No,
lord.
no. If the meeting is being held today, why don't you attempt to get the instructions today?
My lord, I have been calling repeatedly, my lord, by the course of the day, my lord, it will be
So
signed.
we'll follow up the matter again.
Filed an affidavit in the matter. एक मिनट, same document दिया था ऐसे. What's
Yes, I apologize, lordship. I interfered. In this case, lordship, lordship, poor lordship also, lordship. I apologize to the lordship. Paragraph 300 and page 315, lordship. Page 315 of the affidavit filed by
315.
315, lordship. 315, lordship.
Yes.
Last two paragraph also, in the battle between the claimant, my lord, lordship. For the post of principal, the interest of the students and the academic progress of the college is being compromised, and the situation can hardly be allowed to continue. Therefore, the GB of the Gauhati College is given the liberty to initiate the process of appointment of regular principal in accordance with the Assam College Employee Provincial License 2010 Rules 2010 lawsuit. When the post is advertised, the petitioner is at liberty to offer his candidature without prejudice to his contention raised in this case lawsuit. However, the eligibility and other norms prescribed by the UGC for appointment of principal must be adhered to by the selecting authorities. Here, lawsuit, there is a liberty is given to the authorities lawsuit to go ahead with the regular principal, and that was done by the lawsuit governing body, and principals was also subsequently appointed lawsuit. Here, the basic requirement is the PhD for the post of principal lawsuit. The petitioner's degree lawsuit, which he has lawsuit produced, is a fake one, false degree lawsuit. We have received the report from the lawsuit, particular university also lawsuit. Even UGC also lawsuit the on its own lawsuit on the basis of our letter lawsuit. They have lawsuit done a verification and inquiry committee was constituted by the UGC lawsuit. That report also comes. If lawsuit permit, I can place the report tomorrow. Today I have handicap lawsuit.
Very good. Wait on Monday.
Monday lawsuit. I will place that report.
Monday.
Lawsuit.
That is the core issue.
Lawsuit. Already that report is come from the UGC lawsuit. and I'll place it.
And in this affidavit also, my lord, we have indicated,
Wait,
if your lordship will kindly see the pages that I was about to show your lordship, my lord. The lordship may kindly turn to page 284. That is a report received from the university, my lord, from where he was allegedly pursuing his PhD. 284 is the report which was written to the governing body of the college. It is in Hindi, my lord. The translated version is also there. And translated version is at page 283. And 285 is the report which they directly sent to the police. The university directly sent to the police. 285, I am just reading it out to your lordship. In compliance to your above referred letter regarding verification of PhD certificate of so-and-so, PhD examination held in the month of so-and-so sent by you have been verified and found above certificate is totally fake and forged and not issued from this university. So this was sent by the university to the police directly. And a copy of similar information was also furnished to the governing body of the college, which is at page 284. And your lordship will also kindly consider two other orders of this honorable court, my lord. There were allegations by the governing body that the petitioner had removed certain documents pertaining to his selection and all from the custody of the college. With that respect, my lord, page 297 may be kindly seen. This was brought to the notice of the honorable court, and thereafter, my lord, the court directed registration of FIR against him. Page 297, third paragraph. So-and-so counsel appearing for the governing body of the college states that there was a change of the governing body in the year so-and-so, and the earlier governing body is not handing over the original records pertaining to the selection of the lecturers. It is also stated that in this respect that an ejahara was lodged by the president of the governing body, and the said ejahara has resulted in Mukalma case number so-and-so. As indicated above, the records of the appointments of the respective lecturers should be necessary to determine the question of seniority amongst others. Further, as the records are presently stated to be in possession of the earlier governing body, and the earlier governing body is not handing over the records, it is deemed appropriate that the OC of Mukalma station be directed to take possession of the original records from the accused persons in so-and-so and transmit the same to the learned additional senior government advocate so-and-so to produce the same before the court on the next day. But thereafter, although the case was next page, accordingly, OC so-and-so is directed to do the needful. But although the direction was given, my lord, nothing fruitful came forward. Subsequent direction was also issued that your lordship will find at page 310. Mr. So-and-so, superintendent of police, has your lordship got it, my lord? Yes. Mr. So-and-so, superintendent of police, Nalbari, is personally present before this court as required by the order dated so-and-so. Pursuant to the said order, Inspector so-and-so is also personally present. SP assures that he will personally take up the matter to locate the records of the service particulars of the teachers and employees of Gauhati College and will make all endeavors to produce the same before the court on the next date fixed. Please take in on so-and-so. Personal appearance dispensed with. Now, after registration of FIR, this FIR, my lord, the petitioner was taken into custody. He was also for a time suspended from service. But because of the course of events, my lord, the suspension had to be revoked, and he is still there as an assistant professor in history. The fact remains that if the eligibility is tested, then for the post of principal, two things will have to be taken into account: whether or not he possesses the requisite qualification, and secondly, whether he will come within the purview of the cutoff date or not. Now, on these both counts, my lord, my submission is that, my lord, neither he possesses the degree, which is a prerequisite, nor does he come under the purview of the cutoff date, because his appointment was subsequent to the coming of the act. On these two counts, he is not entitled.
And hearing on
Yes.
Monday. Yes. Further hearing on Monday.
My lord, in fact, the affidavit which has been relied on by my senior friend, my lord, has been disputed by the deponent himself.
See that. Heard to the end. And that's all. higher education. Getting made inconclusive on account of the problem necessary for parent. That you 20.
But can it be on next Thursday? Next Thursday, next week? If it is convenient for my lord.
Thursday is 23rd.
Let it be on Monday, let us see. Not in- 21st, we are not certain
No, no,
because of the events which will take place on 20. 19 or 20?
19.
19, all right.
19.
20 would be answered.
20. We'll take a call. Right.
All right, madam.
Matter be listed accordingly on 20. Let us see, because it's a question of perusal of the records. If we find that these are sufficient, we'll close the matter or take it on some other day.
Obliged.
Obliged.
Lord, in this series, they have filed affidavit only in item 22. These are all matter pertaining to GMC, my lord. What had happened, there was a decision taken to regularize the, my lord, ad hoc employees. And my lord, in fact, in a first exercise pertaining to Safai Karmachari, about 500 were regularized.
You are referring to item 22.
My lord, because in item 22, which pertains to junior appointment of 2 junior engineers, my lord, who were appointed on compassionate ground. So lordship should kindly, in other cases, my lord, there was advertisement and all, they were appointed.
Reading the complete here.
Yes, yes.
Okay, GMC because what is
Lord, the bone of contention is, my lord, part of the exercise was done, a part has not been done. Just to appreciate the facts, if your lordship would kindly come to page 43 of item number 22. Page 43 of item number 22. It's an order dated 28th of January 2021. In pursuance to the minutes of the meeting held in the residence conference hall of Honorable Minister GDD with representatives from 5 union bodies of Gauhati Municipal Corporation on 26/1/2021, the following employees are temporarily posted in personnel branch GMC for speedy disposal of regularization work of Gauhati Municipal Corporation employees. My lord, this was the committee which was constituted. Then if your lordship would kindly come to page 44, next page. On 10th of February 21, in pursuance of the approval of the Honorable Administrators of Gauhati Municipal Corporation, accorded in file under Section 71 of the Gauhati Municipal Corporation Act, and in pursuance of the minutes of the meeting chaired by the Honorable Minister GT on 26/1/21, as conveyed by the Deputy Secretary to the Government of Assam GT by memo dated 28/1/21. Read with minutes of the General Council meeting by memo dated 5th of December 2014. The following employees working in Gauhati Municipal Corporation were working within the staffing pattern as approved by the government by letter dated 21/09/17 are regularized as regular Mazdoor in the pay scale of rupees 12,000 to 37,500 with grade pay of 3,900 with grade effect. The employees shall be governed by the new defined pension scheme. So, my lord, in the first batch, up to page number 40, my lord, sorry, my lord, up to page number 52, 500 Safai Karmacharis were regularized. Now, for undertaking the second exercise, at page 53, this order was issued, my lord. In continuance to the earlier order dated 28/1/21, and for the fast disposal of regularization work of Gauhati Municipal Corporation, in respect to minutes of the meeting held in the residence of the conference hall of the Honorable Minister GDD, with representatives from 5 union bodies of Gauhati Municipal Corporation. On 26/1/21, the following employees are temporarily entrusted for updation of all files of all temporary, casual, fixed employees working under GMC. Team will camp at the conference hall of Panbazar from so and direct to complete the work on or before 7/2/21. So, my lord, though the committee was constituted, my lord, but my lord, the required exercise was not undertaken. So, as a result, all these petitions are, my lord, were filed and these are presently pending. And the corporation has filed an affidavit only in this matter. And this again pertains to compassionate appointment. Once compassionate appointment are made, my lord, where is the question of further regularization? As of date, my lord, we are working since 2016.
So all these employees.
Yes.
At, from page 44.
Yes.
They are appointed on compassionate appointment.
No, two person. In this petition, there are only two petitioners. This Vedanta Kolita and one Srimati. No, they were not appointed on, their services were regularized. Here the petitioners are Vedanta Kolita and Sahin Sara Begum. There are two petitioners. Both were appointed as junior engineer, my lord. They were appointed on February 2016 and till date they are working.
What is that order you are challenging? Right?
There is no order, we are seeking a mandamus.
No, there is a prayer for setting aside communication dated 3/0.
Oh, subsequent advertisement. Here, in respect of this matter, there is no advertisement. In one or two cases, there is advertisement.
And what is the stand of the respondent?
They say because of Umadevi it can't be done. That is their plain and simple case. But Milord, now the authority has already taken the decision. So where is the question of Umadevi coming in the way? Because Umadevi is not a restraint on the power of actually, Milord, what had happened? One PIL was also filed regarding regularization of this 500 Safai Karmacharis. That is pending. Or that has been disposed of.
Any specific order there?
No, Milord. I think there was some inquiry. So I think some direction was issued by the division bench for making inquiry.
So in fact, this is a petition of 2022. My affidavit was also filed in the year 2022. Thereafter, the division bench passed the order in the PIL. And therein the direction was issued to the authority to have an inquiry under what circumstances that many numbers of persons service were required. So if Lordship permits Lordship, probably there are certain developments also in between from 22 to 26. And if Lordship takes up this matter after 2 weeks or 3 weeks, I will inquire Lordship if there is any development. If nothing is there, Lordship, then on the basis of these pleadings only Lordship decide this case. Otherwise, I will place that.
At page 94, we have annexed the order of the division bench. In page 94, Milord, in reply affidavit. Page 94. The instant PL has been filed by the petitioner seeking a direction from the respondent authorities to take action against the officers of the Gauhati Municipal Corporation who are involved in regularizing services of 500 contractual employees as regular Mazdoor in Gauhati Municipal Corporation. In the counter affidavit filed on behalf of the respondent number 5, it is stated that in the matter of regularization of 500 casual employees as regular Mazdoor in the GMC, a preliminary inquiry has already been initiated at the Directorate of Vigilance and Anti-Corruption, and the same is in progress. In view of the fact that the Director of Vigilance and Anti-Corruption is already inquiring into allegation of regularization of 500 casual employees as regular Mazdoor in the Gauhati Municipal Corporation, we are of the considered view that no further order is required to be passed in detail. However, it is expected the Directorate of Vigilance and Anti-Corruption of the state shall make every effort to complete the preliminary inquiry at the earliest. Accordingly, the PL petition is disposed of. Now, my lord, my humble submission is very simple. Supposing in this inquiry something is found out, my lord, on principle, the corporation, which is an autonomous body, they have already taken a call, my lord, to regularize these services. So the question of Umadevi coming in the way will not arise.
Mr. Nayak submits that you'd like to.
He can have the updated instruction.
Because
If
that
it,
taken after
okay.
weeks, Mr. Nayak.
In the month of August, Lordship. On 11, 12.
11. 11?
11.
Mr. Kane, so hearing. I submits that permitted to obtain instructions regarding challenge made by the petitioner seeking regularization.
Yes.
Regularization of their services. As the affidavit of the AMC was filed the year 2022. Brings for some time. Where maybe not by the city council accordingly as it is. 11th of August. 11th.
My lord, let the report status from the Vigilance and Anti-Corruption also be placed, because that's the inquiry going on.
The Nayak will also endeavor to obtain the status of the inquiry conducted by the
Vigilance and Anti-Corruption. Lord, in all these cases, there are interim orders, those will continue.
Interim orders, wherever passed, will continue next day.
Deep down.
Yes, Mr. Chaudhary.
Yes, my lord. Well, the matter is relating to and provincialize the service of the petitioner, my lord, who was initially appointed by the lecturer of Somtoli College, my lord. In the year, my lord, 2000, my lord, 1999. Thereafter, he is working, my lord. The college was provincialized in the year 2015, my lord. In the meantime, my lord, I got the, my lord, PhD degree, my lord, from Mogad University, my lord. Along with me, my lord, there are two other persons, Anwar Hussain and Iqbal Idris Ali, also got the PhD degree, my lord. Same time, my lord. Therefore, in the year 2022, I was appointed as a tutor assistant, my lord, because they are not considered my PhD degree. I challenge this order before this honorable court, my lord. And after that, my lord, after challenging the order of this honorable court, my lord, they have, my lord, filed an affidavit in opposition, my lord. First, your lordship can only go through my appointment letter, my lord. That my appointment letter, your lordship will find Annexer 1, my lord. That memo number so appointment letter
page number 15. With reference to the subject cited above, I am directed to say that the sponsoring body of Sondoli Ansolik College is pleased to appoint you as a lecturer in history. Monthly salary so and so. Please note that appointment so and so. Then your lordship will get the my lord my joining letter. On 38/99 I joined my lord. I read that my lord.
You joined in the post of lecturer.
Lecturer my lord. Subsequently, your lordship kindly come to page 17. 16 is the my lord. My appointment letter.
Now this lecturer was re-nomenclatured as assistant professor, or you were promoted?
The school has been this one. The college has been provincialized in 2015. The other person who are appointed as a lecturer.
Come to page number 19.
Page 16, my appointment letter.
19.
19. Yes, ma'am.
Page 19.
Yes, ma'am.
You see that you state that you are an assistant professor. So assistant professor is equivalent to lecturer.
Yes, ma'am.
So earlier it was lecturer, then
Assistant
re-nomenclatured as
assistant. Then your lordship will come, my lord. That, my lord.
So you completed your PhD, and from the same university, two of your juniors also completed, but their cases were provincialized.
Yes,
your case was not considered.
Their case, there are 16 other persons, my lord. In my reply, I have stated, my lord. I cut short, my lord. Why? They are, my lord, file an affidavit in opposition. Your lordship, first, before that, my lord, your lordship kindly go to the, my lord, page annexure 7, page 31, my lord. My lord, if your lordship go to that, my lord, in exercise of our comfort provision, one of the Assam Education Provincial Teacher Amendment Act, in pursuant government sanction order, that the following employee of Sontuli Ansolik Mahavidyalaya Mahatuli Kamuru has been provincialized. They are now employee of the state government with the following terms and conditions mentioned above. The employee who has been provincialized under this act gets some amendment as per norms of the state government as per provision contained in this state. They will be treated as a fresh appointee. They cannot claim the benefit whatever in respect of service rendered by provincialization in respect of this shall be governed by the NPS school. They are entitled with the so and so. My name has been mentioned, my lord, para serial number 3. Here, my name of post general as a name of post as a tutor assistant professor. And my lord, and your lordship kindly go to the my lord. Directly, my lord.
Who are the other three
Yes, my lord, I am
persons?
coming, my lord. Page, my lord, your lordship kindly come to the page annexure 5. Page 27, my lord. In exercise authority conferred 4.1, the venture educational institution when the so in person government sanction letter, so the service of following employees, Sonotoli and Mahatoli, have been provincialized, and they become the employee state government with effect from the date of some against the so. Anwar Hussain and Idris Ali name has been mentioned. I have annexed, my lord, my PhD degree along with, my lord, that Anwar Hussain Idris Ali. My PhD degree is page number 26, ma'am.
This order of 2015,
yes, my lord.
When it was passed, what was your status? You had completed your PhD.
Yes, my lord. You also kindly page 26, 2013, I completed.
And then it was placed before the government.
Yes, placed before the government. Government will take the decision.
They did not take a call.
They did not take any decision. Now they, my lord, if you come, my lord, I will come later on, my lord. Page 26. Abdul Mannan, PhD, date mentioned, my lord, 4/12/2013. Have you also got it?
Yes.
Then, my lord, your lordship will come. Anwar Hussain, PhD degree, 26/10/2013. From the same university, my lord. Then, my lord, Idris Ali, PhD degree, it was taken on 22/2014, page 30.
So your PhD degree is not found to be in accordance with UGC.
That is, my lord, I may submit, my lord. When I go through all these things, my lord. Then, my lord, I have already said, my lord. Then you also kindly go to the, my lord. Their affidavit in the opposition, my lord. Your lordship will come, page 36, my lord. Para 4. That the deponent state, instead of giving para-wise reply, represent deponent deem it necessary to appropriate relevant facts. Para 5, my lord. Page 37. That the deponent says it has come to the notice to the government a number of teacher assistant by newly provincialized college Assam has required master PhD from the university outside the state, but the same is not being in accordance with the UGC regulation. May coming by one, my lord. Then I will. Hence, there was a pressing need to examine genuinity of such degree obtained from university outside the state in order to ascertain eligibility provincial service, such as incumbent. Therefore, in view of the above, Government of Assam Higher Education Department, HC 29/11/2020 constituted a screening committee. Under the chairmanship of so and so former VC, Dibrugarh University for verification of authenticity each and every master degree. Then para 6, that the deponent begs to state that as per documents submitted by the petitioner obtained PhD degree from Magadh University, Bodh Bihar in the month of November 2013. Therefore, while considering the provincial service, the case of the petitioner is also placed before the aforesaid screening committee for verification. The said committee has already thoroughly verified all the documents relating to PhD degree obtained by the petitioner from Magadh University, Bodh University, and found that PhD degree is not in accordance with the UGC regulation 2009. The petitioner has not appeared the entrance examination, that is the crux of this, and also not done coursework for admission to the PhD program, and as such, screening committee has not considered PhD degree to be petitioner authenticate. And the service of the petitioner could not be provincialized assistant professor, but as per section 712 Assam Education Act, the service of the petitioner has been provincialized as tutor assistant professor, fight order dated 14/5/2022. For this reason, my lord, they have stated that you could not be appointed as a assistant, you are appointed as tutor assistant. To that effect, my lord, I give the reply. Lordship, kindly come to the page 41 of my reply. Para 4. That the averment made in para 5 and 6 is incorrect, false, baseless, misconceived, misconstrued, and as such denied by the deponent, who reaffirmed the fact that despite of having the same degree qualification from the same institution which was obtained around the same time, having an earlier date of joining compared to Muhammad Anwar Hussain Idris Ali, the case of the petitioner was not considered for regulation was considered for regulation, and instead of service, that the petitioner was appointed for tutor assistant 14/5/2022. It is pertinent to mention here in that on 19/1/2023, Magadh University, Bodh Bihar, had issued a clarification wherein the said university has stated that PhD regulation 2009 imposed by the UGC was implemented from 2014 in Magadh University, Bodh Gaya. It was further clarified that entrance test and coursework was not necessary for working teacher in college university before 2014. Moreover, the duration of PhD was obtained counted from the term and effect of registration, retrospective registration as per ordinance of Magadh University. It was further stated that by a letter dated 14/11 to the Registrar Magadh University, Bodh Gaya has informed the Director of Higher Education Assam that teacher of university and college holding post permanently and colleges are affiliated by the state university, Indian university eligible for registration for PhD degree without appearing the PRT test up to 2014. Because Magadh University is a deemed university, my lord, they have adopted this UGC regulation in the year 2014. And that is why, my lord, that earlier all this person, Idris Ali, Anwar Hussain, I also, my lord, to degree that was considered, my lord.
But PhD regulation of 2009,
Yes, my lord.
where is the scope for a university not to accept or implement it till 2014?
My lord, I will get that document is available. It was further informed by the aforesaid letter above mentioned teachers are exempted course for PhD degree up to 2014. The petitioner that Nagar University Budga is autonomous institution has every right to formulate its own state bylaw ordinance for the
No, but it can't be in conflict with UGC norms. Cannot be.
that UGC also clarified, my lord, that they have adopted the UGC resolution 2000. That can be done, my lord.
Where is it?
I'm coming, my lord, one by one, my lord. It is mentioned here in the Nagar University Budga has adopted, implemented the uniform UGC ordinance and regulation for award PhD degree only in 2014, not before that effect. The said university had issued notification 12/2/2014. Be stated that as per public notice 17/3/2007, which was issued by University Grant Commission, it was clearly mentioned that the PhD degree which are perused either pursued either full-time or part-time will be treated as degree awarded through regular mode, provided these are in conformity to existing statute, bylaw, ordinance, etc. The degree awarding, however, PhD acquired under distance mode is not permitted. The petitioner further states that as per draft regulation PhD registration, it was provided that teacher having 3 years experience may submit thesis just after registration, retrospective registration, up to 6 term may be given. Vice Chancellor / PGRC in case teacher who have at least 3 years of teaching experience. Thus, from the aforesaid facts and circumstances, it is crystal clear that entrance test and coursework are not prerequisite for admission PhD admission. And as such, the screening committee is not considering the PhD degree of the petitioner as authenticated without giving him a reasonable opportunity of being heard is nothing but a so and so, my lord. Then, my lord, para 5. That is important, my lord. It's 44. That environment many para 7, it is incorrect, baseless, so and so, as such denied by this deponent. The deponent further state that apart from the Anwar Hussain and Idris Ali as mentioned in the writ petition, there are 24 other incumbent. I have annexed this list. Have obtained PhD degree from Megati whose services already been provincial assistant professor in this school. Be stated that 11 incumbent, namely Faraz Ali Ahmed, Anwar Hussain, so. Thus, it is unfair as a part of the petitioner the service of all content possessing same degree got provincial assistant professor. However, his service got provincialized as a tutor assistant professor. As such, impugn proposed action is so and so. Now, your lordship come to the page 47. That has been clarified by the controller of examination, Nagar University. Your lordship knows very well, my lord, the person who has conferred that degree, he can only, my lord, cancel the degree. My degree was not cancelled, nothing has been done, my lord. How can a committee, my lord, can say, my lord, your degree cannot be.
You show us the UGC regulation.
Yes, my lord. I am coming.
At the relevant point in time,
yes,
when you had undertaken your.
Yes, my lord. Page 47, annex
47.
Yes, my lord. I am coming one by one, my lord. PhD regulation 2009 imposed by UGC has been implemented from 2013.
This is the certificate of the university.
Yes, ma'am.
You want to know that you had taken your PhD degree when?
I was taken 2013.
13. So
yes.
In 2013, what was the regulation in place by UGC?
My lord, in 2013, Nagar University, my lord, a coursework and my lord, and then the examination is not necessary, my lord. Yes, ma'am.
In 2013, the exemption given by Nagar University.
Yes, my lord.
What was the prevalent rules under UGC at that point in time?
But that was clarified, my lord. Yes, my lord. I shall produce, my lord, later on, my lord. First, you will not kindly come to page 47, my lord.
47 is irrelevant for us because this is a certificate, self-certificate given by the university.
Yes, then you will also come to
we want to
page 50.
know the status of the.
Yes, my lord, coming, my lord, page 50.
That is document, my lord. I am coming on that. Annexure D. Have your lordship page 50. Clarification regarding regular mode to develop PhD degree. University Grant Commission regulation minimum qualification for appointment teacher. Other academic staff university college measure maintain a standard of higher in 2010 amendment notified gazette on 11.
How did you acquire the PhD degree?
My lord,
During your service?
I am on regular, but I appeared in the practical exam and other all these things. my lord.
While you were applying for PhD,
Yes, my lord.
were you in service?
Yes, I am in service.
You were in service.
Yes, my lord.
So, for you to go and regularly attend the classes and all, you must be permitted by the college authorities.
My lord, your lordship kindly come to my lord. Annex page 50, my lord. What has been clarified, my lord. Mention that PhD should be regular mode. UGC has been receiving the queries from various stakeholder universities seeking clarification with regard to the definition of regular mode. The commission PhD at the meeting 25 considered the issue. This is a PhD which shall pursue either full-time or part-time. Have you also got it? I have appeared all like part-time. I am appearing in the my lord university. My lord. Part-time will be treated as a degree awarded through regular mode, provided these are in conformity with the existing statute, etc. of the degree awarding. However, PhD degree, etc. of the degree awarding university. Have you also got it? That is the crux of the issue, madam. Degree awarding university, madam. However, PhD degree acquired under distant mode is not permitted. I am, my lord, regular mode I have done, my lord.
Part-time.
Part-time, my lord. And what is the rule of the university? There has been clarified that document also, my lord. 47, 48 also, my lord, said. If you lordship go to the 48, my lord, that is I am coming one by one, my lord. Pursuant to the MU notification, so and so, 2012, the statutory syllabus Board of Research is different subject which prepare syllabus MA, MSc, PG, the pre-registration course material that has been I given. In the light of UGC Ordinance 2009 for PhD has already been implemented by the university. The course material is to be prepared by the committee with 1 month from the date of notification and to be submitted to the office of the registration. I have given this, my lord. Next page. Let us come to the next page. That was clear to the higher education by the registrar of Mogad University. This is inform you that the teacher university college holding the post of permanently college or affiliated state university association university eligible for registration for PhD without appearing PRP test. What they have said, my lord. Up to 2014. That has been clarified, my lord. And UGC has said what college has been made, the rules and regulation by law, that will be excluded, my lord. It is also the PhD degree, they are the exemption from PhD up to 2024. I got the 2013 PhD degree. Then they have prepared a draft, my lord. Anyway. Coming, my lord. Now, your lordship, this is the draft rule, my lord. One page is missing, my lord. Thereafter, this honorable court has directed to produce that document I have given. And it was numbered at, your lordship, kindly page country 51A and 52. I have given. This is the draft, my lord, rule, my lord, of the university, my lord, has prepared. And if your lordship come to the, my lord,
Mr. Gugoi, you examine this matter from the standpoint of the rules, regulations, and
Regulation very much clear 2009 regulation also. There should be coursework is mandatory.
No,
also.
2009, the university says we have not adopted.
They
till
cannot
14.
proceed. They cannot dilute
So
the.
us, that is what we are asking.
They cannot dilute the minimum procedure prescribed by the UGC laws.
What happened to the other junior persons which they claim had also done it from Mogad and they are now regular?
If something wrong was done, all are under the law scrutiny and so cause notice was issued everyone. When the persons who are involved, that particular exercise also lawsuit, disciplinary proceedings are facing it.
why not?
When did you obtain your degree? 13.
13, my lord. And November 2013. My lord, how can a committee, my lord, in the crux of the has a power to scrutinize my degree, my lord, and my lord, if they say
No, they are not saying that your degree is false or forged or
yes,
anything.
my
They are
lord.
not saying.
Yes, my lord.
They are saying that the degree you have obtained,
Yes, my lord.
but it is not in terms of the
This
UGC
is notification.
regulation.
That's why we are not acceptable.
Therefore,
that
they are not considering this degree to be of
Has-
equivalent.
Yes, my my humble
Well,
submission.
lordship, similar, not the exactly similar. Here, condition is the coursework is not there as per the UGC's required qualification. Lordship. Some of the persons who have the PhD degree, lordship, research supervisor as per the UGC's notification should be, lordship, from that particular university or the college which is affiliated to the university. Some of the cases, lordship, the persons who have obtained the PhD degree, the research supervisor is, lordship, not as per the UGC's regulation. Lordship. That was also decided by our High Court, lordship. Their degree, the not acceptance of the degree is not violated by the authority. Lordship. It was also decided by our High Court. Lordship.
May I come in, my lord? Let me.
I'll place
Yes,
everything.
my lord.
I'll
I shall submit everything, my lord. I am also arguing this committee has no power, no authority, my lord, to de-recognize my degree, my lord. I will use the degree.
Why are you on this, harping on this point that they have de-recognized? They have not de-recognized. Your degree is there.
Yes, my lord.
They, according to them, as per regulation 2009,
Yes, my lord.
since the degree procedure prescribed was not followed,
Yes, my lord.
they are not considering your degree.
My lord, how can they say, my lord?
Because the UGC norm, UGC regulation says,
UGC has clarified this issue, my lord. I have annexed this document. I have already read this document, my lord.
that
This
is,
is in respect of lordship, regular.
May I
not
submit,
for the
my lord?
coursework, lordship.
How
Nothing
can
is
a
there, lordship.
committee say, my lord, when UGC has said that this is not necessary and what the university rule will be made, my lord, they said that that will be followed. Now a committee, my lord, which is a, my lord, if it is a commission, that is also different aspect of the matter. Who can done all these things? It is can be done by the UGC. Whether UGC, my lord, recognize my degree, well, we will not consider your degree. UGC never said all these things, my lord. Magat University also not said. There are, moreover, there are 26%. I have annexed the list. All the degree from the Magat University. And there also, my lord, their service has been provincialized. You cannot do pick and choose basis. Committee said, I like X. This degree will be recognized. And I will not like. Your lordship, kindly come to the Annex 5, page 27. I have read, my lord. His service has been provincialized. How can their service has been provincialized? Nothing has been said in the affidavit, my lord, about these things, my lord. Affidavit is silent about this matter, my lord.
did you clear this at the time of entrance,
Yeah, my
I mean,
lord.
at the time of undergoing PhD,
Yes, my lord.
did you clear any this JRF SLET gate
No, man.
for MPhil program?
No, man. That was not required, my lord. Because 2009 was not for the university 2014, that position has been accepted by the UGC, my lord. Out of the way, a committee constituted by the my lord, Assam government under the Dibrugarh University, DC of Dibrugarh University gave an opinion.
Now, one could say that these UGC guidelines are not binding on the university.
Yes, my lord, that is the
That, do you have any authority to base your submissions?
that, yes, my lord, that letter is this letter, my
No,
lord.
not letter. Authority means judgment of the court, of the Supreme Court, of the High Court, to say that
I am
UGC guidelines are not binding on university.
on certain way I have a judgment, my lord. I am coming one by one. Then, my lord, they have to say what he has submitted, that we are scrutinize all the degree. As per my instruction, they are not scrutinized. They are happily working, man. All the person who has degree.
I have the example also.
Example not well. I have given 26%.
I have the High Court cases, lordship. Almost lordship, 30 cases is pending before his honorable court, lordship. Where I have issued so cause notice for disciplinary proceeding. Why their service should not be terminated, lordship.
No, discipline is something different. Before they are,
This is the,
before they are,
at the relevant point of time.
Disciplinary proceedings on the ground that their degrees are not recognized.
No, Lordship, that
They
now
do not satisfy the eligibility.
not satisfy the eligibility criteria. That was the benefit was given only by the some officers, Lordship, on the personal gain. I just say, Lordship, they have do it, Lordship, malified intention. That particular officer facing the, now, Lordship, he is also facing the bail, Lordship. And he is also, Lordship, under suspension also, Lordship. When disciplinary proceeding also going on, Lordship, after reinstatement, he was removed from the department also.
So you show us the effect of the
annually,
regulations.
annually, institution, my lord, let them produce the order. If this is an annual session.
Let him place his case, Lordship. I will reply on the law point, Lordship.
Yes,
Let him
ma'am.
place the
Yes,
case,
my lord.
whether he is entitled or
Law
not.
point, my lord. Para 5 and 6, my lord.
He has to stand his own footing, Lordship, not for others. Lordship.
He has submitted, that is why I give reply, my lord. I shall give, that's a pending. That was, my lord, passed by our High Court, my lord. Para 5 and 6. A university degree in excess of power under section 22 University Gum Commission under Rule 21 clauses. The degree obtained university, it is only university who can declare the degree obtained untenable on law or may withdraw it. No third party can be understood to have jurisdiction authority not to accept a degree offered by university in excess of power under section 22 of the UGC 2056. Then we are unable to accept the view formed by the Director of Secondary Education dated 27/7 as because the petitioner so and so obtained MA degree without obtain NOC of previous permission authority. Therefore, the degree would be unacceptable as per rule. From such view, the petitioner can be made up.
So this will,
Yes,
has
ma'am.
the regulation been discussed here?
Yes, ma'am.
UGC regulation,
Yes, ma'am.
where?
Yes, ma'am. Yes.
Then, Lordship, as they also have, Lordship, raised that particular pertinent question, Lordship. UGC is the necessary party here. They have not made the UGC the party also here, Lordship.
Let us first see the
But
regulation.
just
Yes, ma'am.
I have indicated.
Right to confirm, my lord, like is not available.
Which act?
UGC Act 22. Yep. 22. Right to confer degree. Right to conferring granting degree shall be accessible only by university established incorporated under the Central Act and Provincial Act, State Act, and institution university section 3 or institution specially empowered by the Act Parliament. Save as for no person authority shall confer, grant, or hold himself entitled to confer or grant any degree. This is right to confer degree.
UGC Act, fine. Very good. Very good, nine.
Huh?
Huh?
Huh? Let's let them. The form is very simple.
Give us a copy of the act.
I have my lord. That part, my lord. That is fine. Let's send it. We can.
So this is the same copy.
Yes, ma'am.
Give us the complete act.
I shall.
Act is not there.
So I said, what is Lordship fixed it on Monday. I shall put it all down.
Monday. That day. Twenty-eight.
Yes,
28 July.
Yes, one.
John, 23rd or 22 also.
It will be done in August.
My lord,
10th August, 12th August, 12th August.
First,
Released on 12th August on the request made by
can it be 10 by
10th August. The request made by Mr. Counsel for the petition. Place the relevant legislations. Released on 12.
can it pardon, my lord? Because
10. Want it on 10.
yes, madam.
10.
Can
10.
it get the pardon?
Not part.
My lord, I tried my level. You look how many days I have waited for this case, my lord.
Next date we'll make it part. We'll have to go for the hearing. Mr. N.G. Chaudhary, Senior Counsel, assisted by Mr.
Kashyap.
Kashyap. Mr. P. Gogoi for the higher education.
My lord, we pray for adjournment for the day, my lord, and matter may be fixed of 20th August, my. And for the respondent 2, 3, 4, and 2.
Yes.
Time for response.
Why you pray for an adjournment?
No, the matter will be argued by my senior, my lord.
What did you say, Mr. Chaudhary? The request made on behalf of the Council for the Secondary Education. The arguing council is not available.
No, your lordship, they are for appearing for SEBA.
SEBA.
Assam Higher Secondary
Higher-
Education.
Assam Higher Secondary
Education.
Education Council.
Yes.
At this time referred to state 12th of August. The really Chaudhary with the petitioner and his team class for secondary.
Yes, your lordship, for respondent.
education.
I'm deeply offended.
I think 35.
Any update?
I'm just awaiting the final approval, my lord. It has not come. The
All right, tomorrow 10:30
Medical come.
is underway, and some decision is likely to be taken today. Submits that the matter be pulled up tomorrow.
instruction will be provided by you.
Provide the necessary instructions. Mr. Pathak. Not of the chairman, Mr. Bora, hearing for the health department also submits that the matter will be listed tomorrow. Mr. Pathak, however, submits that there is an urgency in the matter as decision will have a material effect on the
Upcoming PG admission.
what admission?
Easy, postgraduate admission.
Postgraduate admission of the